Hola a todos, ya se van conectando. Vamos a esperar un par de minutos. Esperar un par de minutos. Vamos a partir en 2 minutos para los que ya van sumándose ahora de último. Ya. Ya, vamos a partir. Entonces, bienvenidos a todos en representación de la Universidad de Concepción y IFA Rama Chile. Queremos darles la bienvenida a todos a este interesante webinar. Ojalá que puedan interiorizarse de cuáles son los últimos desarrollos en temas de tributación internacional. Son temas altamente relevantes, si bien a nosotros un poquito los chilenos se nos olvida qué es lo que está pasando afuera en el mundo, esto es lo que está siendo discutido. Eh, Iba a partir con una exposición Cristóbal Pérez Jarpa, lamentablemente tuvo una emergencia médica, pero tenemos al mejor reemplazo que pudimos tener, que es Gonzalo Vergara. Gonzalo es socio de PwC Chile, cuenta con una destacada trayectoria en materia de tributación internacional. Tiene más de 15 años de experiencia asesorando a empresas multinacionales y ha liderado procesos de implementación de medidas BEPS y asesoría clave en aplicación de convenios para evitar la doble tributación. Además de que es reconocido por su enfoque sumamente práctico. Así que Gonzalo nos va a contar un poco sobre el contexto mundial en tributación, en donde estamos parados actualmente, y entender cuál es la pugna, cuál es la situación que tenemos actualmente entre la OSD y la ONU. Así que Gonzalo, te cedo la palabra. Muy bienvenido.
Muchas gracias. Bueno, y gracias también por el ascenso. ¿Se ve ahí bien la
Sí,
presentación?
¿verdad? Sí,
Sí,
se ve.
sí, perfecto. Bueno, como Cristóbal no pudo acompañarnos, la idea es un poco, antes de escuchar las presentaciones de los expositores internacionales, recordar un poco o en algunos casos, ya que como contaba María Paz, muchas veces nos perdemos bastante en nuestros propios problemas respecto de hacia dónde va nuestra propia tributación. Es fácil no recordar en qué están los temas internacionales. ¿Avanzó ahí?
No, falta ponerla en modo presentación, Gonzalo.
Ah, es que está en modo presentación. A ver, tal vez sí.
Este es el clásico que está con dos pantallas y en una se ve como presentación y en la otra.
Es malvada, no sé por qué no quiere.
Ahí se ve bien en todo caso,
Ya,
si queréis seguir así.
ok, sí, que me ha ganado
La tecnología.
la tecnología. Bueno, ¿en qué está la OCDE y la ONU? Bueno, hay que recordar en esto el tema de los pilares que parten en el año 2009. Y ese año, cuando el mundo era tan distinto, que ahí pueden ver que Barack Obama y Vladimir Putin eran amigos. Y esto parte justamente en San Petersburgo el año 2009, para que ustedes vean cómo el mundo ha cambiado. Y ese año se acuerda este proyecto BEPS, que es encargado por el G20 a la OCDE. Es decir, que es un proyecto que involucra, va mucho más allá de la OCDE, que normalmente, o sea, si bien los norteamericanos participan en ella, ha tendido a ser una entidad más bien europea. ¿Y qué es lo que la OCDE termina acordando? Y la OCDE crea un programa que se llama BEPS, que es este programa para evitar evitar la erosión de la base imponible. Y este programa estaba compuesto por dos pilares. El primer pilar buscaba crear un nuevo factor de conexión. ¿Por qué un nuevo factor de conexión? Porque el factor de conexión tradicional, que era el establecimiento permanente, que permitía, que daba la facultad a un país para aplicar los impuestos directos respecto de la actividad, eh, tenía que estar esa actividad realizada por personas o por cosas dentro de un país. Es decir, qué es lo que no capturaba el establecimiento permanente y no capturaba toda esta economía digital que inicialmente se pensó que se podía capturar de una manera distinta, pero finalmente terminaron dándose cuenta que el avance de las actividades tradicionales hacia la digitalización era muy alta. Entonces, debido a que el establecimiento permanente solo capturaba actividades que incluía que estuvieran personas o máquinas en un lugar, y excluía las actividades que se calificaban como secundarias, que con estos nuevos modelos de negocios digitales se comenzaron a transformar en actividades principales, como el almacenaje, decidieron que era necesario un factor de conexión completamente nuevo, distinto del establecimiento permanente. Y respecto de ese primer pilar, ¿qué es lo que ocurrió? Bueno, ocurrió que los países grandes nunca se pusieron de acuerdo, y como nunca se pusieron de acuerdo hasta el día de hoy, no hay avances respecto de la distribución de la tributación en materia de renta para el caso de la economía digital. Es decir, Netflix, todo lo que en Chile terminamos grabando con el IVA, no hay un acuerdo internacional. Sin perjuicio de eso, varios países crearon estos impuestos a los servicios digitales, y esos impuestos a los servicios digitales esencialmente buscan reemplazar esta tributación en la renta. Chile tomó la otra opción y, siguiendo el principio de destinación, Chile aplicó el IVA a los impuestos, o sea, a los servicios digitales. Y el pilar 2, que causa toda esta polémica y que va a ser analizada por los expositores, ¿qué es lo que buscaba este pilar 2? Y el pilar 2 buscaba contrarrestar lo que consideraban la competencia fiscal desleal entre los países. Más que porque el tema de la deslealtad era una calificación bastante emocional, no era una especie de calificación jurídica, pero un poco lo que buscó la OCDE era detener la competencia fiscal y establecer un piso de tributación en materia de renta a nivel mundial. Y ese piso a nivel de tributación en la renta, la idea no era aplicarlo a todas las empresas, sino solamente a empresas grandes, a empresas multinacionales grandes, y la definición en ese sentido es bastante simple: son multinacionales con ingresos consolidados dentro de todo el grupo de 750 millones de euros. Son euros, lo cual da cuenta de que este es un proyecto bastante europeo. ¿Y qué es lo que busca? Esencialmente busca este pilar 2 hacer tres cosas. La primera es uniformar las bases imponibles de estas grandes multinacionales a nivel mundial. Es decir, que el cálculo del tributo mínimo global se aplica sobre una base unificada que está establecida hasta cierto punto en instrucciones de la OCDE, que están inspiradas en los principios financieros. Uno de los problemas de estar inspirada en los principios financieros, entre otras cosas, es que los principios financieros actualmente contienen un montón de valorizaciones, es decir, que muchos de los valores utilizados para este cálculo en rigor son opiniones de una persona que dijo, sabe que el inmueble que usted está arrendando tiene un valor que consideramos justo de tal monto. Entonces, uno de los problemas es que muchos componentes, o sea, además de la complejidad, de la alta complejidad de las reglas, como se basa en principios financieros, muchos de ellos en rigor son opiniones más que hechos. Es decir, no hay un cálculo sobre la base de transacciones, sino que de estas valoraciones. Bueno, el segundo objetivo es que sobre esta base unificada a nivel mundial se aplique un impuesto mínimo de un 15%. Y con esos dos objetivos, un poco se detiene en la mayoría o en muchos países, por lo menos en los países europeos, se detiene o se pone un piso a esta competencia fiscal. Pero todas estas reglas tenían un tercer componente del cual nos van a hablar los expositores el día de hoy, que implica que se cobra cuando el impuesto, porque ¿cómo se cobra este impuesto mínimo global? Y las alternativas son tres. La primera es que lo cobre el país donde está situada la filial. Imaginemos Chile, imaginemos por un momento una compañía minera chilena, entonces Chile podría cobrar ese impuesto del 15%. Conforme a este cálculo, es decir, que con independencia de la tributación que corresponda a esta minera en Chile, se hace un nuevo cálculo a nivel global que incluye a esta filial chilena, y en ese nuevo cálculo se termina estableciendo si está pagando un 15% sobre esta base que no es la base legal chilena, sino que es esta base que ha sido creada por la OCDE y los países europeos. Entonces imaginemos por un momento que no se cumple, imaginemos por un momento que hay diferencias temporales importantes y está pagando menos de un 15%, que la mayoría de los países sudamericanos, como tienen tasas bastante altas, en general no han considerado que estas normas les serían aplicables a las empresas multinacionales que operan en la región. Salvo ciertos casos por ejemplo, que Colombia tuvo muchos incentivos, entonces existen casos en los cuales consideraban que muchos de los incentivos que estaban aplicando esos países de la región no eran considerados para efectos de la base imponible de este Pilar 2, por lo que se terminaría aplicando una mayor tributación. Ahora, ¿cuál es el problema que vamos a ver respecto de eso? Que provoca esta revuelta que vamos a ver en un momento que partió en África. Que con esto un poco lo que hace la OCDE es imponer o limitar las políticas de desarrollo de los países pequeños. Bueno, entonces imaginemos que Chile no cobra este impuesto. Entonces, ¿quién pasa a tener derecho a cobrar ese impuesto? Y es el país donde está situada la matriz. Entonces, imaginemos que es una minera que es propiedad de una empresa francesa, por decir un caso que aparentemente no existe, pero Francia podría aplicar este impuesto del 15% conforme a esta base calculada, conforme a reglas que fueron establecidas por la OCDE, a la matriz en Francia. Hasta cierto punto, hasta ese momento es bastante similar a lo que ocurre con las reglas, las famosas CFC, que son estas reglas sobre entidades extranjeras controladas. Entonces, no parece ser algo particularmente terrible. Pero en el segundo punto es donde comienza el conflicto importante. Imaginemos que esta matriz está situada en India, que la matriz está en Chile, que la filial, la matriz está en India, porque normalmente es como ocurre que vienen del extranjero, nos hemos ido achicando nosotros como país en vez de agrandarnos. Ya, pero imaginemos que la matriz está situada en India y la filial está en Chile. Y hay otra filial situada en Francia. En ese caso, si Chile no cobra este 15%, porque no tenemos reglas sobre el Pilar 2, si la India no cobra este impuesto, porque tampoco tiene reglas sobre el Pilar 2, en teoría, a la filial francesa, que puede ser una sociedad hermana que no está dentro de la línea de propiedad, Francia le podría cobrar este impuesto del 15%. Es decir, que tenemos un cobro completamente extraterritorial simplemente porque existe dentro de uno de los territorios europeos que han implementado estas normas, una filial que, conforme a su informe consolidado del Pilar 2, tiene utilidades en un tercer país que no es Francia y en el respecto del cual esta filial no es dueña, estamos hablando de una sociedad hermana, y le pueden cobrar a esa empresa sin que esa empresa tenga participación en la cadena de propiedad. Entonces, es eso, como vamos a ver en un momento, es la parte más eh, que provoca más contingencias en este momento, políticas. Bueno, ¿qué había ocurrido en paralelo con Estados Unidos? Y Estados Unidos, bajo el primer gobierno de Trump, creó estas reglas llamadas GILTI. Estas reglas llamadas GILTI tienen similitudes, pero también tienen diferencias muy importantes con las reglas de la OCDE. ¿Y qué es lo que buscan estas reglas? Y estas reglas se concentran principalmente no en actividades productivas, sino que en lo que nosotros podemos ver en nuestra legislación como rentas pasivas y principalmente en propiedad intelectual e industrial. Entonces, lo que buscan estas reglas es capturar y grabar en Estados Unidos las rentas provenientes de la propiedad intelectual e industrial, principalmente, más otros activos considerados al final del día como pasivos, si queremos usar la nomenclatura de nuestras CFC, y obligan a tributar en Estados Unidos a las empresas y a los nacionales de Estados Unidos. Pero, ¿cuál es el objetivo que ahora con el segundo gobierno de Trump queda un poco más evidente? Lo hace tributar, y un poco lo que desea esta normativa, que es lo que quiere lograr, es repatriar esos activos, es decir, que está dentro de todo este proyecto de Trump un poco de que vuelvan las actividades y los activos a Estados Unidos. Luego, ¿cómo pasamos del consenso a la discordia? Inicialmente, bajo el gobierno de Trump, Trump creó sus reglas GILTI, pero no se involucró mayormente con el Pilar 2. Bajo el gobierno de Biden, en un momento casi al final del único periodo de Biden, Janet Yellen, que aparece ahí, viajó a una de estas reuniones y terminó anunciando que Estados Unidos iba a aceptar el Pilar 2 y que esencialmente se suscribió este acuerdo de los países que están acá involucrados, que entre otras cosas se comprometen a no establecer legislación que sea contraria a lo que acabamos de ver. Y entonces todo parecía color de rosa, pero de pronto en la propia Unión Europea se comienzan a presentar impugnaciones respecto del Pilar 2. Y en Bélgica en particular hay ya un cuestionamiento de la constitucionalidad de estas normas. Después, los países africanos, más como vamos, se subieron a ese carro en el último momento también los países sudamericanos, pero la iniciativa estuvo liderada por la Asociación Africana de Administraciones Tributarias y lograron un voto en la ONU para sacar a la OCDE de la discusión de toda la tributación, de cómo se iban a negociar todos los convenios internacionales y en particular cómo se iba a negociar esta distribución que está pendiente, que tiene que ver un poco con el pilar 1, que es cómo va a tributar en materia de renta los servicios digitales. Y hay un cuestionamiento, por supuesto, respecto de qué es lo que va a ocurrir incluso con el pilar 2, pero principalmente la discusión busca tomar el control de lo que aún no se ha resuelto. A raíz de esto y a raíz de que asume el nuevo gobierno de Trump en paralelo, y el nuevo gobierno de Trump anuncia que se retira del acuerdo del Pilar 2 y por lo mismo va a implementar legislación que va a ser contraria al Pilar 2, lo que se produce es que China e India, que son dos de los actores importantes a nivel mundial en la economía, dicen, ¿saben qué? ya que no les gusta a los países menores, no les gusta a los norteamericanos, nosotros tomaremos palco y miraremos y deciden tampoco implementar estas reglas. Entonces tenemos que Estados Unidos tiene sus reglas GILTI, tenemos que la Unión Europea tiene este pilar 2, que incluso fue implementado el, por el Reino Unido, que estaba en esa época, digamos, los posteriores gobiernos no lo han eliminado. Y al mismo tiempo, Trump anuncia que puede usar en contra de los países que apliquen tanto las reglas del Pilar 2 como las reglas relacionadas con el IVA a los servicios digitales y los impuestos específicos a los impuestos digitales, podría aplicar una facultad que fue concedida hace muchísimos años, pero han existido históricamente amenazas de usarla, pero nunca ha sido utilizada, en la cual el presidente de Estados Unidos puede considerar que si existe un país que está aplicando reglas, ya sean extraterritoriales o reglas discriminatorias en contra de empresas norteamericanas o de ciudadanos norteamericanos, puede aplicar en Estados Unidos a los nacionales, sean empresas o individuos, les puede aumentar la tasa de los impuestos. Es decir, está esa amenaza real en materia de impuestos. Ahora, en paralelo, y esto es algo que los tributaristas en Chile por lo menos estábamos acostumbrados a no poner tanta atención a lo que ocurría con los aranceles, Estados Unidos comenzó a usar los aranceles como un arma de negociación, pero es un arma de negociación que va más allá de los aranceles y va más allá de los impuestos, porque ¿qué es lo que están buscando en este momento? Y quieren los norteamericanos cambiar el equilibrio internacional en materia de comercio, quieren que la actividad industrial regrese a Estados Unidos, o sea, son unos objetivos bastante ambiciosos, y además quiere que no se aplique el pilar 2 a los norteamericanos, ni empresas ni a los individuos. Y tampoco que se aplique IVA ni estos impuestos digitales especiales que han implementado ciertos países a los servicios prestados por empresas e individuos norteamericanos. Y en este caso, en teoría deberían ser el IVA y estos impuestos digitales se deberían aplicar de manera discriminatoria. Ahora, obviamente, el problema es que quién define que es discriminatorio y por lo menos en el nuevo paquete de normas que se presentó Estados Unidos al Congreso, un poco lo que se busca es que el Ejecutivo tenga a su discreción se califique que algo es discriminatorio. Y Estados Unidos, y ahí la pregunta, ¿querrá terminar con el Pilar 2? Y quedó claro, porque inicialmente parecía que iba a querer casi terminar con los OCDE, pero la nueva ley, el proyecto de ley que se presentó y que ya fue aprobado por la Cámara de Representantes en Estados Unidos, un poco lo que da cuenta es que Estados Unidos dice, usted Europa siga con su Pilar 2, a mí no me interesa en la medida que no se aplique a los norteamericanos. Ahora, ¿en qué están los países sudamericanos por su parte? Y los países norteamericanos a partir del año 2003, a raíz de este movimiento de la discusión desde la OCDE a la ONU, los países sudamericanos están agrupados, casi todos ellos, porque Argentina no se terminó incluyendo en este, y vamos a ver en un momento por qué, están agrupados en la CEPAL en una plataforma en la que ellos hacen propuestas a la ONU. Y estas propuestas en general tienen un contenido político bastante alto, están concentrados en que los impuestos sean progresivos, en que se concentren los impuestos en la actividad climática, lo cual es un poco en qué se usa el dinero, no en qué se recauda, y están concentrados un poco en eliminar los beneficios tributarios. Ahora, ¿por qué se salió Argentina? Y queda un poco en evidencia cuando vemos a quienes han sido invitados a discutir en este foro. Y esencialmente han sido invitados a discutir organizaciones que están en la izquierda política. Entonces, por lo mismo, Argentina con el nuevo gobierno no entró a esta plataforma. ¿Y qué es lo que proponen? Y proponen crear a nivel de la ONU una organización que administre impuestos climáticos, es decir, quieren crear una burocracia, una administración tributaria supranacional que cobre impuestos a nivel mundial. Quieren transformar en calidad de derecho humano lo que son en rigor varias políticas fiscales, como la progresividad, y quieren eliminar los beneficios fiscales en una especie de equivalencia al presupuesto cero, pero respecto de los beneficios fiscales en los que ellos vayan siendo eliminados. Y para eso proponen modificar las constituciones de los distintos países e inclusive quieren que los ministerios de Hacienda puedan derrotar las decisiones del Congreso que busquen, por ejemplo, bajar los impuestos. Entonces, tiene un contenido político bastante alto y está bien un poco a la izquierda de del espectro. Entonces, un poco como reflexión final de en qué está el mundo en este momento. Y por un lado tenemos este cambio radical en el cual se traslada la discusión tributaria desde la ONU a la OCDE, pero la OCDE ha seguido operando como si nada hubiera cambiado y mientras un poco el entendimiento que ellos tienen es que mientras el G20 no le diga haga algo distinto, ellos van a seguir promoviendo la misma agenda que tienen hasta ahora. Por su parte, la ONU no está partiendo de cero en esta nueva discusión porque hay que recordar que la ONU tenía un modelo de convenio que ese modelo de convenio que tiene alteraciones, parte de la base del modelo de la OCDE, y hace alteraciones un poco para permitir que los países en desarrollo puedan hacer tributar rentas que en el modelo de la OCDE normalmente quedan solo en el país de la residencia. El ejemplo clásico es la propiedad intelectual, que en el modelo de la OCDE ellos consideran que debería tributar solamente en el país de la residencia y no en el país de la fuente. En cambio, en el modelo de la ONU permite que el país de la fuente pueda imponer con límites un tributo a ese tipo de rentas. Ahora, el modelo de la ONU, que es seguido no solo por los países, sino que si ustedes revisan, por ejemplo, lo que dijo el gobierno norteamericano cuando explicó al Congreso el tratado con Chile, cuenta que Estados Unidos también en varias cosas sigue el modelo de la ONU. Entonces, es decir, que no es simplemente algo que se aplique solo a los países en desarrollo. Y Estados Unidos, ¿en qué está? Esencialmente no tiene interés en que se eliminen las reglas del Pilar 2, simplemente lo que dice es no aplique bajo ninguna circunstancia estas reglas a las empresas norteamericanas. Pero además de no querer aplicar el Pilar 2, y es donde probablemente porque aún no lo sabemos, porque Estados Unidos se ha concentrado principalmente en negociar con los países más grandes, un poco los países sudamericanos fueron a negociar, pero están hasta cierto punto, los tienen a todos esperando en el lobby, no los han recibido aún. Pero gran parte de los problemas que podríamos tener es esta calificación, que no sabemos cuál es la visión aún de los norteamericanos respecto del IVA, de la aplicación del IVA a los servicios digitales y la aplicación de estos impuestos digitales que tienen algunos países como Colombia, que, bueno, en el caso de Colombia excluye la aplicación de ese impuesto cuando hay un convenio. Entonces, no sabemos si en estas negociaciones los norteamericanos, por ejemplo, porque parece que a los europeos les van a exigir eso. Entonces, puede que a nosotros también nos diga, ¿sabe qué? No hay más IVA para Netflix. y es una de las cosas que se van a negociar. Y por lo mismo, como final de esta conversación, lo que podríamos terminar es con las empresas que están situadas en Chile, que son de capitales extranjeros, se podrían ver afectadas tanto por GILTI como por las normas del Pilar 2. Es decir, quedaríamos en un mundo en el cual somos objeto de tener que nuestras empresas tengan que cumplir con esta tributación extraterritorial tanto de los europeos como de los norteamericanos al mismo tiempo, porque es probable, porque recordemos que GILTI no fue cambiada durante el gobierno de Biden. Es decir, que si Trump está a 4 años y después vuelven los demócratas, parece improbable que los demócratas terminen eliminando GILTI y por lo mismo lo más probable es que nos tengamos que acostumbrar a convivir con con tener que cumplir dos regulaciones distintas de países extranjeros. Así que ahí, no sé, María Paz, si...
Sí, muy interesante, Gonzalo. Ahora, pareciera que nosotros estamos en términos chilenos como el jamón del sándwich. Entonces, ¿cuáles son, crees tú, los desafíos prácticos que va a tener, sobre todo Chile o los países de la región? ¿Tenemos capital político internacional como para poder hacer algo y no quedar en esta situación que pareciera de bastante como indefensión tributaria?
Sí, la verdad es que el capital político de la región es bien bajo. Argentina, que tenía buena
Mm.
relación personal el presidente de Argentina con Trump, también le aplicaron o anunciaron la aplicación de este impuesto estos aranceles del 10%. Y en paralelo, tenemos que países como Uruguay, que estábamos justamente ayer hablando con gente de Price Uruguay, eh, Uruguay es uno de los países que se ha visto más afectados porque Chile, a diferencia del resto de la región, se había preocupado de tener una política en materia de aranceles, de apertura al mundo total y de negociar. Y Chile prácticamente el 90% de nuestras exportaciones estaba cubierta por tratados de libre comercio. Por lo
Claro.
tanto, si bien Estados Unidos es tremendamente importante para nuestras exportaciones, no es nuestro único mercado.
Mm.
En cambio, en el caso, por ejemplo, de Uruguay, ellos tenían solo un 10% de su comercio exterior cubierto por tratados de libre comercio y por lo mismo el golpe de los aranceles para ellos era mucho más grande y en la región al final nos terminaban tratando a todos de la misma manera, un poco sin tener consideraciones como políticas respecto de la región, dijo un 10% para toda esta región.
Claro.
Entonces, el gran problema que tenemos para efecto de ir a negociar es que no tenemos nada que sea exclusivo, como en el caso de China o Europa, que han tenido que ir bajando, bajando el termómetro y decir vamos a bajar. En el caso de China dijeron, partieron con unos aranceles muy altos, después los fueron bajando. En el caso de los europeos han ido posponiendo el momento en que van a entrar estos aranceles, van a comenzar a regir. Pero en el caso de Sudamérica, el problema es que no producimos nada. O sea, si bien, por ejemplo, somos uno de los principales exportadores de cobre, no somos el único exportador de cobre. Somos uno de los
Claro.
principales exportadores de litio, pero no somos el único exportador de litio. Y, por ejemplo, en materia de litio, ya que es un poco los efectos cuando nos empezamos a poner un poco más inseguros en la región. En el caso del litio, en la última como gran exposición de autos y novedades electrónicas en China, comenzaron los chinos ya a presentar baterías nuevas que son
Claro.
híbridas y que la mitad funciona con otra tecnología que usa sal. Entonces, un poco nuestro peso para negociar es bastante bajo porque, o sea, son historias un poco que se repiten. Si recordamos cuando vivíamos del salitre,
Claro,
bloquearon a los norteamericanos con el salitre y o sea, perdón, no bloquearon a los alemanes con el salitre y los alemanes inventaron
el
el
salitre
salitre
artificial nomás.
sintético. Claro, y ahora tenemos a los chinos ya presentando con bombos y platillos baterías híbridas.
Sí,
Entonces, hasta cierto punto nuestras exportaciones funcionan solo en la medida en que no sean caras. Y por lo mismo un arancel del 10% puede que, y ahí tristemente están todos los representantes de los países de religión están esperando,
¿qué
porque ni
pasa?
siquiera, claro, están esperando qué pasa porque en este momento la capacidad de negociación de los norteamericanos está copada por los países más grandes.
Así es. Bueno, muchísimas gracias, Gonzalo, por la presentación y el contexto. We're going to switch to English now, and we're going to welcome our foreign speakers. So, joining us from the Netherlands is, I'm going to do my best effort to pronounce it correctly, uh, Blazej Kuzniacki. Is it kind of right? Blazej? Kind of?
Voici.
Blazej. No?
Yes, yes,
Okay.
perfect. Hello.
Professor, an international recognized expert in international tax law. He holds a law degree from Lazarski University in Warsaw, an LLM and a PhD from the University of Oslo, and has lectures in institutions such as the Singapore Management University and the University of Amsterdam. And currently, he's part of the global tax policy at PwC Netherlands. Professor is particularly known for his critical work on the compatibility of UTPR with non-discrimination provisions in tax treaties. So we are excited to hear from him. We have a few questions at the end of the presentation, so keep in tune. Professor, the floor is yours.
Thank you so much. Thank you so much. I will share the screen with the presentation, and please just let me know if you can see the slides.
Yes.
Okay. So you see the presentation is phrased in the form of the question: Is the UTPR compatible with non-discrimination provision under tax treaties? It's a very difficult and technical question. We will try to answer to that question as clearly and as intelligibly as possible, and then we will break it down into few additional questions. But Maria, feel free also to interrupt me on an ongoing basis and engage into discussion. This is the outline for this presentation. So first, some introductory considerations, whether and why it is at all important to consider compatibility of UTPR with tax treaties, why non-discrimination principle plays here a special role, I would say key role, and some excursus. Excursus is important because it shows or it takes you into the direction into the most recent developments in the area of global rules and their future. So challenges from this policy side, the US, but also new technical arguments, and then we will conclude. So let's focus already on the first part, which is like introduction and strategic considerations for the UTPR in light of international law. When we speak about international law and compatibility of domestic rules like Pillar 2 UTPR with international law, it's good to look first at the very basics, very foundations. So where is the list of sources of international law? There is no really like close-ended list because international law is in a way still emerging and developing. But you can look into Article 38 of the Statute of International Court of Justice, Article 38, paragraph 1, and then in the subparagraphs A, B, C, you will have a list of sources of international law, starting with international conventions, written international law, and here I indicated those sources that are of relevance to UTPR. So tax treaties, the source of international law that is of overarching importance for the presentation now, but also EU treaties for EU member states and third countries investing in EU and vice versa, and investment treaties. I will touch all of them a bit, but with the focus on tax treaties. Now, another source is international custom. Here we may find some school of thought according to which UTPR is not compatible with the nexus for income taxation. And I indicated that it's debatable because there is no agreement whatsoever, even among scholars, whether there is customary international law that has something to say about it. It's still a question mark. And the last source, general principles of law. And here, the principle of non-discrimination will be discussed today, but also there are other two principles important for UTPR, proportionality and good faith. What is important to consider even before we move to the technical analysis? Well, it's clear that not every component of Pillar 2 is in the same way problematic under international law. But what is clear is that UTPR, what is also clear is that UTPR is the most problematic because in comparison to QDMTT and the IRR, the UTPR seems to be most vulnerable to legal challenges under various sources of international law, including tax treaties. And I did some research about Chile, and Chile has not that many tax treaties, 37 double tax treaties, but Chile has a way more investment treaties, 55 IAs, which is abbreviation for International Investment Agreement. Therefore, in my presentation, I will make from time to time excursus to investment treaties, and I will indicate why it is important while discussing non-discrimination principle. This slide shows another strategic consideration, not of the theoretical nature, but more of the practical nature. And I think we will discuss a bit more with the moderator why it's important. Because, as you know, Pillar 2 rules work as a kind of trap mechanism. Namely, if one country does not charge 15% effective taxation by the primary rule, then another country may by UTPR. But also a country may decide to have defensive rule, in other words, QDMTT. So you may question why anyone would like to challenge UTPR if by winning the case in front of the court, the same tax will be inevitably paid in another state, IRR state. If there is no IRR to be charged, then it will be QDMTT, etc. But well, that's a bit wishful thinking because it all depends on many circumstances, on the actual presence of an MNE in scope, whether it's US MNE, whether it's Chinese MNE, for example. Both countries without Pillar 2 yet, so there will be none of these rules applicable. Whether we deal with intermediary entity in European Union or not, whether there is some exemption, and I could continue and continue. But important here from strategic litigation perspective, also arbitration perspective, basically all types of dispute resolution is that QDMTT is easiest to challenge because it is most questionable under various sources of international law. So if an MNE prevails in legal challenge against UTPR, then only two rules will stay to think about it, IRR and QDMTT, but there may be no IRR, so they may be only QDMTT. Of course, this is all up to the actual circumstance. So the question is if you need to challenge UTPR only in one state or maybe in more states. But UTPR also on the compliance side, so not only on the side of the effective 15% taxation, but purely just to comply with the rule triggers enormous burden. So try to deactivate UTPR is effectively will contribute to the reduction of the compliance costs in terms of working hours devoted to that compliance, but also financial resources massively. It may also lead, as we will see in the end, to the activation of Pillar 2 in respect to some MNEs entirely. So now, the key element of the lecture, non-discrimination. Before I will discuss non-discrimination under tax treaties, let's, for a minute or two, look at the non-discrimination as for international general principle of law. So non-discrimination, depending on the context and the branch of international law, can be seen not only as a general rule of law, but even as a customary international law, for example, in the relation of fundamental human rights. Professor Reinisch and Schill, in their book published by Oxford University Press 2 years ago, observed that non-discrimination principle aligns with core values that any system of law deserving the name, whether domestic or international, aims for. So it's very fundamental principle. It can be found in the most fundamental source of international law, which is UN Charter, in Article 1, Paragraph 2 of the 1945 UN Charter. Basically, every country needs to respect the principle of equal rights, or the principle of non-discrimination, if you like. One of the judges of the International Court of Justice, Judge Tanaka, in Southwest Africa second phase case, and dissenting opinion, reminded to us that non-discrimination can be traced back to the philosophy of Aristotle, and that non-discrimination has two sides, not only one-sided. Namely, this principle requires, and I cite now, not only the equal treatment of equals, but also consideration of differences in assessing whether different treatment is just and is geared to achieving de facto equality, not just formal equality. I emphasize that because this de facto equality, or de facto non-discrimination, is key to recognize that UTPR is problematic under non-discrimination principle. And let's now focus on the most important element, formally speaking. So it's the non-discrimination under tax treaties. So scope and the key rule. Here we have the model convention, OECD model convention. This phrasing for non-discrimination principle is also replicated in the UN model convention. I focus here only on the non-discrimination as applicable to enterprises, but of course there is also reference to permanent establishment and to natural persons, to individuals. But companies are most affected by UTPR. So let's look at Article 24, Paragraph 5, which says, I will cite now, enterprises of a contracting states, the capital of which is wholly or partly owned or controlled, directly or indirectly, by one or more residents of the other contracting states, shall not be subjected to the first mentioned state to any taxation or any requirement connected therewith, which is other or more burdensome than the taxation and connected requirements to which other similar enterprises of the first mentioned state are or may be subjected. So it's in a way quite far-reaching. You see, it's not only about different effective taxation that may trigger non-discrimination, the principle, but any other or any more burdensome taxation that companies in the same countries are subject to. Very important for UTPR. It is also vital to factor in that under all rules in tax treaties, non-discrimination applies to all taxes, not only to income taxes or taxes on capital. In other words, as you see in Paragraph 6, non-discrimination shall apply to taxes of every kind and description. So whether or not UTPR is income tax doesn't matter. Non-discrimination still applies. But in practice, of course, what is not OECD model or UN model is not legally binding. What you need to look is the actual tax treaties ratified by two countries. And here I did more research on Chile, and I focus on the two I may be wrong, but I think one of the most important Chilean tax treaties with the US, and the next one with the Netherlands. So what says US treaty with Chile in comparison to the model? Well, it replicates more or less the wording, but then it says in paragraph 6 that first replicates the wording, stating that non-discrimination applies to taxes of every kind and description, but then the US-Chile tax treaty provides with exception. It states, except that in the case of taxes not covered by this convention, the provisions of this article, non-discrimination, shall not apply to any taxation laws of a contracting state that are in force on the date of signature of this convention. It's very important point for treaty dodging. I will come back to it. But it means that, like, because UTPR was not in force at the time of the conclusion of the treaty between Chile and US, it's new tax. You see, 2010, we have 2025, 15 years after at least, implemented in Chile. It is fully covered by non-discrimination. It's not within that exceptions. Situation is different in the treaty between Chile and Netherlands, in which Article 24, paragraph 6, we can read that non-discrimination applies only to taxes that are subject of this convention. So here it's very important to check whether UTPR lies within the scope or ambit, enters the ambit of Chile-Netherlands tax treaty, because if answer is negative, then even non-discrimination principle does not apply. But I devoted a separate slide to treaty dodging and will explain why UTPR shall be considered as covered by Chilean tax treaties, including Chile-Netherlands tax treaty. Okay, so now an illustration which I hope will zoom on at non-discriminatory nature of UTPR in the meaning of tax treaties. So in the first scenario, we have ultimate parent entity in country A. It's non-implementing jurisdiction, for example, United States. And then we have non-implementing subsidiary in country B and implementing jurisdiction in country C. So subsidiary in country C is subject to UTPR, which is more burdensome taxation in comparison to any company in country where there is no UTPR taxation. Second scenario, we have implementing jurisdiction. So we replace US in country A with, let's say, Canada or Korea or Japan. And then you have subsidiary in country B, non-implementing jurisdiction, no UTPR, and then subsidiary in country C and subject to UTPR accordingly. And the final scenario, again, implementing jurisdictions A and C and non-implementing jurisdiction B, so no UTPR there, but UTPR in country C. So in all scenarios, you can read more about it in this blog post I wrote together with Ms. Vergoven. It's open access. But what we can extrapolate from these three examples? Well, the key factor to activate UTPR is the under taxation, the taxation which is below 15% effectively at the level of the group, where the entity is subject to taxation less than 50%, and there is no taxation under QDMTT or IRR elsewhere, then that entity is subject to taxation to top-up tax in the entire amount, globally speaking, depending, of course, how many entities is. So it may be a lot, maybe a bit less. But the decisive factor is the lack of implementation of Pillar 2 at the level of the parent company, typically ultimate parent company. So then the subsidiary is subject to UTPR. But as you see in other scenarios where ultimate parent entity is in a country which implemented Pillar 2, therefore QDMTT or IRR will capture 15% tax, will impose 15% tax, then UTPR is deactivated, right? So it's clearly less attractive for the subsidiary C to have parent in a state which did not implement Pillar 2 from the purposes of UTPR taxation and the UTPR compliance burden. So UTPR in itself creates a significant obstacle for cross-border investments, significant restrictions where and how M&E can invest and then conduct commerce. It is discriminatory. Well, it seems it is discriminatory, but let us look closer why, in my view, it is discriminatory. Among experts and scholars, you will not find one convergent opinion whether UTPR is discriminatory. You will find opinion that UTPR is not discriminatory, at least is not precluded under non-discrimination principle under tax treaties, and I call it narrow and formalistic approach. This approach is championed by the OECD, of course, because OECD designed UTPR, and the same position is represented by the European Union, we can assume, and some scholars. So what the narrow and formalistic school of thought says? Well, it says that non-discrimination principle under tax treaties does not preclude all types of discrimination, but only one type of discrimination, namely that which differentiates solely on the basis of one criterion. This criterion is the residence of a foreign owner or controller of the local subsidiary subject to tax, more burdensome taxation, right? And UTPR does not fall within the scope of such preclusion because UTPR is activated only if M&E globally crosses the revenue threshold of 750 million euro, and moreover, the effective tax rate is below 15%. So we have two factors which are on their face not related to the residence of the foreign owner and controller, and as a result, non-discrimination doesn't exist, but it's not this discrimination that is precluded by non-discrimination principle under the treaties. So, long story short, even if UTPR discriminates against some constituent entities, local subsidiaries, which are owned or controlled directly or indirectly by foreign enterprises, it is not the discrimination precluded under Article 24 of the OECD Model Convention or relevant articles of the Chilean tax treaties. I do not belong to that school of thought. I belong to the second school of thought, which I call broad and substance over form, according to which UTPR is discriminatory in a way that is precluded under tax treaties because UTPR is actually activated as a result of tax residence of its parent in a state without Pillar 2 rules. And they are not negligible states. On the contrary, they are states that are some of the most powerful economically, politically, and militarily in the world, namely US and China, with huge investments around the world, including in South America, and I believe in Chile. So this observation is very important for practical purposes. It is by no means restricted to academic discourse. And I call this discrimination in disguise. So it's not obvious discrimination. It's not the type of discrimination that is obviously precluded by tax treaties non-discrimination principle, but this discrimination that is precluded, this discrimination in disguise. If we take the mask from the face of the UTPR, we see the face which is not welcomed under tax treaties. There are many other justifications for it that are less important, but also worth considering. One is to look at the specific purpose of Article 24, non-discrimination, in conjunction with the general purpose of the treaties. So the specific purpose is to eliminate obstacles to cross-border investment and commerce stemming from discriminatory taxation. Does the interpretation provided by the broad and substance over form approach to non-discrimination eliminate such obstacles or not? Created obstacles created or triggered by UTPR? The answer is positive. Also, the general purpose of the treaties is to facilitate cross-border investment and trade by elimination of double taxation, of course, juridical double taxation. Is such taxation eliminated by following broad and substance of reform approach to non-discrimination principle vis-a-vis UTPR? The answer is again affirmative. We may also look at the principle of systemic integration under Article 31, paragraph 3, subparagraph C of the Vienna Convention, which requires to interpret a tax treaty, for example, a tax treaty or any other tax treaty, by taking together with the context, so we are in the reign of contextual interpretation, not only the wording of the treaty, but also any relevant rule of international law that is applicable between states, for example, between US and Chile, or Chile and the Netherlands. And I will speak about that below a bit more in respect of investment treaties. Before I switch to the next slide, if non-discrimination principle precludes taxation under UTPR, there is full stop. Its legal challenge is effective because there is no possibility to justify discrimination under tax treaties. It is absolute rule, absolute principle, is not subject to any deviation and justification. If we look at the OECD commentary, well, the OECD champions very narrow approach to non-discrimination. So we have only passport example which go beyond this formal discrimination or obvious discrimination. But it's already a hint saying, well, OECD recognizes that not only obvious formal discrimination, direct discrimination is precluded, but also discrimination in disguise. Of course, this passport example refers only to nationality and to carrying a passport, but it may be extrapolated by analogy to companies. And too narrow reading would be at odds with the purpose of non-discrimination principle and the general treaty. I identified also international jurisprudence in Germany and in India, to give you a few examples, in which courts went so far to say that it is clear that not only overt direct discrimination is precluded by the treaties, but even indirect discrimination. And the fact that UTPR triggers indirect discrimination is, I think, quite clear. So what judges may say in the future, well, depending which school of thought will be followed by them, more convincing for them, the answer may be yes, UTPR is discriminatory and precluded under treaties or not. But I tend to say that judges will be more keen to conclude that UTPR triggers disguised discrimination, which is precluded under treaties, and they will follow more German and Indian jurisprudence. So that was the core of this view. And first, excursus. Prohibition of discrimination under investment treaties. Why it's important? Well, it's very important for Chile because you have 20 more investment treaties than tax treaties. So it would be silly to focus only on tax treaty challenge in respect of UTPR without factoring in any challenge under investment treaties. So what investment treaty case law says about non-discrimination in respect to taxation measures, such as UTPR? Well, we have few precedents which are of assistance here. One of them is the case Occidental Ecuador 1. In paragraph 177, arbitral tribunal stated that what matters for non-discrimination is the result of the policy enacted and the interpretation followed by tax authorities. In fact, in that case, in fact, has been less favorable of the foreign investor. So arbitral tribunal said here, even if formally the wording does not discriminate, if actually, as a matter of application of UTPR, I will use now analogy, there will be discrimination, that is discrimination precluded under investment treaty. If we speak about NT, which is the so-called national treatment standard, so a specific non-discrimination clause. But we have also very broad clause, very broad investment treaty protection, which is called FET in abbreviation, which stands for fair and equitable treatment. And one of the core elements of fair and equitable treatment is non-discrimination. For example, the tribunal in case Rumeli versus Kazakhstan in paragraph 583 explicitly stated that state conduct cannot be discriminatory. It's enough that it's discriminatory to find that fair and equitable treatment is violated. But of course, it varies depending on the circumstances. So as long as UTPR is de facto discriminatory, it may violate Chilean investment treaties. Well, you may say, but there is a global consensus, arbitral tribunals will take it into account. Of course, but there is no, I mind you, there is no international agreement. This so-called consensus is only policy consensus, and we see how quickly and strongly policy may change. Compare the policy approach to UTPR and to Pillar 2 today with the previous administration in the US, just to give you an example. And what says investment treaty jurisprudence on tax policy versus actual wording? Well, here we have an illuminating observation of Khan versus India, Khan tribunal in Khan versus India case in paragraph 1588. And we can read there, as for the Khan paid no tax, so Khan was the taxpayer investor subject to taxation in India. As for the Khan paid no capital gains anywhere in the world, line of argument, this, in the tribunal's view, really goes to matters of tax policy, not the law, which are matters for legislators, not the tribunal. The tribunal must decide on the basis of the law, irrespective of what its members' views may be as to the overall fairness of the transaction from a policy perspective. So the entire fairness versus what is fair tax, what is not fair tax debate is a policy debate. If countries want to ensure effectiveness of the UTPR, for example, among all Pillar 2 rules, they should enter into they should enter into international treaty, or they should change investment treaties and tax treaty wording to that effect. As long as such changes are still somewhere in the air, there is no compatibility ensured for sure with certainty. And moreover, beyond UTPR, investment treaties ratified by Chile and enforced in Chile may be also relevant for purposes of legal challenges against QDMTT and IRR. So altogether, you build more like a broad litigation strategy against UTPR and Pillar 2. That was first excursus. Second excursus to tax treaty dodging. So why is it important? Well, it's important because according to OECD, as far as I know, UTPR is not a type of tax that is covered by the OECD or UN Model Tax Convention, and therefore treaties that are based on those conventions. Is it correct? I'm not sure about it. You will find in the models and also in the Chile, Netherlands, and Chile, US treaties statement that tax treaty shall also apply to any identical or substantially similar taxes, which are imposed after the date of signature of the tax treaty, in addition to, in place of the taxes mentioned in paragraph 2. I would say that UTPR is substantially similar to income tax in Chile, corporate income tax in Chile, which was implemented in addition to corporate income tax in Chile to target only specific companies that are in the groups crossing the threshold of 750 million. So it's a type of tax on elements of income which is substantially similar. If tax authorities in Chile and any other country state to the contrary, that is example of treaty dodging, tax treaty dodging, which means that the country design of domestic tax and new tax, the UTPR, was sought to circumvent obligations of that country under that country tax treaties. And it does not seem to be a good faith approach to fulfilling obligation under tax treaties. But so far, we have only one challenge against UTPR, and it's not even a challenge, which is astonishing, by a taxpayer, but by the American Free Enterprise Chamber of Commerce. Of course, that entity represents the interests of many US taxpayers, many US MNEs, but the point to be made is that it's not really actual M&E. It's just this non-profit organization, and it's in front of the Belgian court. You see 4 key challenges: violation of the right of property, no tax treaty here, European Convention of Human Rights, freedom of doing business and legality, which is Belgian constitution, general principle of law, EU treaties, no tax treaty again, violation of principle of equality and non-discrimination. Here is important for our discussion. The argument is that UTPR applies equally to 2 different categories of companies. And this argument I did not develop previously specifically to refer now. Namely, UTPR applies both to loss-making companies and companies with sufficient profits, which is against to what Judge Tanaka observed by referencing to the Aristotle perception of non-discrimination, which is to treat different entities differently. Here we have example when UTPR treats in the same way a very different situation where we have companies with losses versus companies with profits, which is a violation of the very traditional concept of non-discrimination. And also we have challenge regarding the principle of legality combined with the principle of territoriality, which is very close to the argument that UTPR violates customary international law, which regards nexus for income taxation. And for each argument, there is a request for a preliminary ruling to the ECJ. Why? Because if ECJ decides that UTPR violates some of those principles, rules, then UTPR may collapse globally. Again, why? Well, because I will show it later. Without EU, basically UTPR will have no future or will lead to absurd expropriatory results. The last excursus is to the current US policy against Pillar 2, specifically against UTPR. Then the question is whether UTPR is discriminatory. Again, important question, because as you may know, US once considers to activate Section 891, which is the law against foreign extraterritorial or discriminatory taxes. And also, US considers to implement the new Section 899, which is specifically aimed against digital service taxes and UTPR. So the consideration whether UTPR is discriminatory is also key to activate US defense against UTPR. I wrote an article about it. Again, it's open access for free. You can read about it a bit more. Now, just 2 more minutes. What happens if this Belgian challenge will end up before the Court of Justice, and the Court of Justice will say, yeah, UTPR is discriminatory. So we have no UTPR in EU. Then look where you will end up. You have 1 country in North America, 2 so far in South America, maybe I am not up to date, 3 in Africa, and 7 in Asia Pacific. The less countries with UTPR you have, the more taxation in a single country 1 company will pay. It may be even a situation that 1 company, let's say in some African country, Nigeria, will have to pay 1 billion tax under UTPR, although that company has only 1 million income. That will be the result of it. The less UTPR, the more UTPR, the more countries have enforced UTPR, the more rational outcome will be, but also the more compliance burden, etc. So UTPR is really very problematic, not only for US. To conclude, there is clearly a risk of violation of international law by all Pillar 2 rules. It's not small risk. It's important to consider that risk when advised to the client, especially if you are advisor which is in charge of strategic tax advice and dispute resolution consideration. And among all rules, UTPR is most problematic under all Pillar 2 rules, and non-discrimination under tax treaties is very important source of law to consider to conclude whether UTPR is legal or it's not legal. And here is more like non-legal observation. The very states that decided to implement Pillar 2, not the OECD, not the EU, shall think how to ensure compatibility of UTPR with their legal obligations, because the states are obliged to comply with legal obligations, not international organization, in that case, which is behind the design of the UTPR. So states should not wait for the results of litigation, but of course they will wait for the results of litigation in Belgium, and then they will decide what to do. So that's all on my side.
Thank you so much.
Back to you. Yeah.
Yeah. Okay. So quick question. It's never really quick, but from a policy perspective, do you think that the OECD has adequately addressed concerns about discrimination in Pillar 2 guidance, or are further clarifications needed to ensure compatibility with treaty law? I think we know the answer, but we're keen to know your expertise on it.
Yes, OECD will say nothing about it because discussing this matter would mean that they see problem, but they act as if there is no problem. So why you want to discuss something that doesn't exist? That's the approach. We don't have consideration of discrimination in the materials provided by the OECD much, or if you find anything, it will be argument that UTPR is not a type of discrimination, does not lead to a discrimination covered by treaties. That would be the answer of the OECD.
How do you think courts might approach this issue?
So if a judge is facing that question, I think that more or less it's more likely than not that the judge would state that UTPR is discriminatory.
Mm-hmm.
The actual reason why OECD is not very worried about it, I mean, a judge or an arbitrator, is that the thinking is, okay, if you don't pay UTPR in Korea, you will pay UTPR in Japan. If you don't pay UTPR in Japan, you will pay UTPR somewhere in EU, etc., etc. So you cannot escape it. Economically, you cannot escape it. That's the reasoning of the OECD, and that reasoning you can find in the OECD guidance released in July 2023, and then incorporated into model rules and consolidated commentary. Although it's directed to challenges under, I would say, more under investment treaties, but the wording is broad. It says if there is a challenge of QDMTT under superior law, mm-hmm. then it is considered that QDMTT is not payable. Therefore, any state with IRR or UTPR may automatically apply those rules. Although you paid, let's say your client, a taxpayer paid QDMTT, mm-hmm. but paid and challenge it, then it's considered to be not paid with all economic consequences. So OECD wants to discourage you to even dare to examine compatibility by any administrative, any legal means your country may offer in the legal system. Nothing about UTPR, but by analogy, the same reasoning would apply to UTPR, although it doesn't need to, because UTPR is the last rule.
Okay, perfect. Thank you so much for your presentation. It was really clarifying. So now we're gonna give way to Dr. Vasiliki Koukoulioti. Vasiliki, are you there?
Yeah.
Here she is. She holds a degree from the University of Athens, an LLM and a PhD from Queen Mary, University of London, and she has worked with PwC on other major international firms. You are now a professor at Queen Mary University, and you specialize in tax and technology. So we are keen to hear your presentation, and the floor is yours. Hopefully,
thank you very much.
What we're gonna do with multipolarity.
Yes, thank you so much for the invitation and the introduction. I think the first presentation covered a similar topic, the landscape in the international tax governance and the shift to the UN. Unfortunately, I don't speak Spanish, so I was not able to understand what was covered, but there might be some overlaps, and yeah, maybe the audience will have already heard some of the topics covered, but hopefully I will approach the same topic from a different perspective. I have prepared some slides, and
Great.
they will
See if you
help
can put them up.
everyone follow my presentation. I hope you can see them.
Yes, we can see it.
Okay. So yeah, as already mentioned, I will cover the topic of multipolarity in international tax governance. So in this context, I guess it's important to understand what we mean by multipolarity. But before that, I want to say why I use this framework to describe what is happening right now in international tax governance. So I would like to use this framework to understand the reasons that led to the recent shift of the discussions to the UN, but also to assess the promises of this shift and whether we should be positive and optimistic about significant redefinition and understanding of international tax governance, or whether this is not a promising shift and nothing will eventually change in international tax governance. So this is the outline of my presentation. I will start with some general observations of multipolarity in global governance, not just tax governance. And I will try to cover this from a more or less a historic perspective. And then I will turn to global tax governance and try to look the recent developments from the perspective of multipolarity. Then I will continue by applying this multipolarity reality as I decide to interpret the word order from this lens. And I will try to classify different reactions in 3 different groups. What I call the establishment, critical, and hegemon reaction. And I will close with some general observations of why this framework might give us some more satisfactory and accurate answers to what is happening right now. So starting with multipolarity in global governance. So what we describe with multipolarity is the phenomenon of the emergence of new global powers that replace or coexist alongside existing powers. So instead of having a single polar that exerts power and influence, there are these other interests and groups of like-minded powers that arise and emerge. From a historic point of view, just to maybe help everyone to familiarize themselves with this concept, is we had in the post-Cold War era the emergence of the US as a sole superpower. So this could be characterized as the unipolarity era. And this, of course, meant that also economic governance was dominated by liberal ideas, liberal economics. But then we have recently seen, especially after the recent financial crisis of 2008, which, to be honest, doesn't seem very recent anymore, but we still feel the consequences and aftermath of this financial shock. We started seeing some other blocks to emerge gradually. And of course, there is no unanimity or agreement on whether we have multipolarity or not, because there are commentators that believe that still the US is a dominant economic power, followed by China. So all the other powers cannot compete any of these two superpowers, but there is evidence to support that there are some poles that have emerged, and not necessarily individual countries, but also regional blocs. And here I mentioned some of them. As I said, of course, we've seen China becoming an economic superpower, exerting economic and cultural influence globally. India, with the rising population, has also, and with Indonesia, they also dominate in the region. And then there are very significant and influential regional blocs of countries like BRICS, ASEAN in the Southeast Asian region, and LatAm, of course, in Latin America, which you are all very aware of. And these regional blocs are starting to not only organize themselves around the common problems and interests in their region, but also they try to exert international power and influence, starting and departing from their common interests. And of course, we have the African countries that it's a very interesting example in the tax area, which I will cover in a bit. And African countries, they, of course, are classified as the so-called developing world, but there is a lot of dynamic, especially due to the rising population, especially compared with the aging population in the Western world. So this could maybe describe very briefly how different polars are starting to emerge. And then, of course, the multipolarity framework is seen from a different perspective depending on which discipline we're looking at. In international affairs, multipolarity is usually understood as the reason for this, the unstable world order, which is manifested through regional wars or through the very disappointing mishandling of climate justice, and other historical, of course, elements such as colonialism and the nowadays legacy of colonialism. So in international affairs, they look at multipolarity as an element that creates a lot of friction. In global trade, if we use this discipline to look at multipolarity, is considered as the result of weakened institutional and economic dominance of the global north. So usually multipolarity is looked from the perspective of how the global north has started to lose its influence and power, and then it was replaced, and it's still replaced by regional powers and the creation of strategic alliances that are departing from the global north dominance. And then, of course, multipolarity should be distinguished from regime complex. Usually, with regime complex, we try to describe situations with overlapping institutions that usually have competing interests, but not necessarily. And this is what the regime complex has been used recently to understand the landscape of international tax, where we have the UN and the OECD as two organizations with overlapping agendas. However, multipolarity describes a much broader situation that looks at the distribution of power and the coexistence of different polars of powers, which can, of course, be competing. So from this point of view, the regime complex could be a symptom of multipolarity. And of course, there is an impact of multipolarity on international coordination and cooperation, which is very relevant to international taxation. So it's usually seen as a threat to the creation of the international community and as a reason for fragmentation of the international community. However, there are also voices, especially from international law scholars, that consider multipolarity as a promise for marginalized powers, marginalized countries, to fill this void that can be created when a hegemonic power is not able to impose its interests on the rest of the world. So multipolarity can also create this space for different voices to be heard. So moving now to global tax governance and how we might have experienced multipolarity over the years. So I consider that multipolarity has been so far until recently, and maybe the cutting off point is the BEPS project. So until the BEPS project, we could see how multipolarity was masked in the cases where international coordination on taxation was established. And I will look at three potential reasons for this masking of multipolarity. So the first is, as is written on the slides, is the bilateral structure of the international tax regime. So as we all know, in international tax, the framework is shaped by bilateral tax treaties. And there are a few multilateral instruments, but they all build upon the bilateral structure. And the recent multilateral instrument for the implementation of the BEPS measures is also an additional reinforcement of this bilateral structure, to the extent that it is effectively trying to conserve the bilateral instruments, the bilateral tax treaties, by allowing their amendment in a more efficient and quick way. So the bilateral structure masked until recently multipolarity, because the general narrative behind bilateral tax treaties was that they try to accommodate differences between the negotiating states. So even though most of them rely on a specific model, which was initially the OECD model, but then the UN model, which is also relying on the OECD model to a large extent, they allow bilateral negotiations allow some leeway for introducing differences in the text of the bilateral agreement, so that they can accommodate differences, economic particularities, or cultural or legal particularities in the contracting states. So the idea behind the functioning of tax treaties was always this positive sum game, that everyone benefits from them. And especially from the perspective of developing countries, it was usually phrased in the context of their possibility and their agency, that they have the freedom to negotiate them. And to the extent that they decide to do it is because they have benefits from these bilateral tax treaties. And of course, we have also some other structural elements that support this accommodation of different interests, which is observations and recommendations that, or some special comments that member states can express on the way the model agreement will be implemented through bilateral tax treaties in their case. So there was this narrative around tax treaties, but of course there were voices challenging this narrative, either from the perspective of the idea that this is not a positive sum game, and that there are path dependencies that force developing countries to negotiate tax treaties, even though they are not beneficial. And of course, it's well known to most of us, academics, practitioners, that even though there are deviations between tax treaties, there is a general similarity element, which derives from how the basic normative principles and the basic ideas of international tax have been initially designed and conceived by the League of Nations in the 1920s. So this is how the bilateral structure has managed to create this covert uniformity to cover and mask multipolarity. The second element is what I call the unipolar forum. So until recently, the OECD was the dominant international forum for discussions on tax matters. And the UN was trying to develop this counterbalancing power where it was effectively supporting the interests of developing countries, but it was usually coming in the aftermath of decisions taken by the OECD. So it was a general understanding that the OECD was a dominant forum for tax negotiations. It was sometimes even called the War Tax Organization. And of course, the way the OECD managed to do that was using the pretext of technical discussions. So it was masking the political importance, the political discussions that were happening at the same time. So that was a way to effectively say that we are not representing developed countries' interests because we are discussing technical matters, and there is an objective truth, to some extent, some scientific validation in what we are discussing. So that was a way to mask that behind these so-called objective, scientific, technical discussions, there were political interests, economic interests that were not taken into account or were sidelined for the purpose of supporting developed countries' interests. And finally, is what I call unipolar literature. So from this point of view, we've seen that academic literature on tax matters is what used to follow this pattern of technical discussions. So the literature on the historical underpinnings that led to the current tax framework was very limited, as well as literature coming from the Global South was very limited or underdeveloped. And as a result, there was this reproduction of biased conceptions around how an international tax system works. So this was maybe what I would describe the way the multipolarity that was already emerging was covered, was masked. And then, of course, the cutting point, as I said earlier, was the BEPS project, which was a project initiated by the OECD and led by the OECD. But eventually, it led to some pressure for change. And the reason was, to some extent, the starting point, let's say, was the inclusive framework and how the inclusive framework allowed all these peripheral voices to participate in the discussions, despite, of course, all the criticism against inclusivity and legitimacy. So the very existence of the inclusive framework has played this contradictory role. On the one hand, it was criticized because of the lack of actual participation, but on the other hand, because of its very existence and all the criticism that arose from the problems of how it was structured and the timing of its structure, this gave rise to considerations and concerns, and allowed developing countries that participate in the framework to voice their concerns. So it gave them a stage to exist. That was probably the most important element that initiated discussions around the existence of these other powers that are not satisfied with the way the international tax system functions. And it was voiced both in terms of procedural elements, but also in terms of substance. So this was, let's say, the initial elements that formed what later on materialized as the shift of the discussions at the UN. Another element, of course, was the two-pillar solution, which was the main achievement or the main promise of the BEPS project. And the two components of this solution was Pillar 1 and Pillar 2. With regards to Pillar 1, which tries to reallocate taxing rights to market countries, the narrative from the OECD was that that developing countries will benefit from this proposal because especially some of these developing countries are big markets with many users, so they will benefit from the reallocation of taxing rights. However, there have been impact assessments that try to measure the impact of the tax revenue impact of this proposal, and they usually try to underline the fact that Pillar 1 cannot be examined in isolation from the existing double tax services, digital services taxes that many countries have implemented. And considering that Pillar 1 will be introduced and would require the abolishment of DSTs, there have been studies that consider the introduction of Pillar 1 in combination with abolishing DSTs doesn't bring many revenues, tax revenues, or as high as high as expected tax revenues to developing countries. So that's with regards to Pillar 1. And of course, all the questions about whether this proposal will move forward. And with regards to Pillar 2, which seems to be more feasible, at least to some parts of the world. Again, the narrative has always been from the OECD that this proposal benefits developing countries because it protects them from profit shifting, and also because it ensures that developing countries do not need to use and implement wasteful tax incentives, for example, tax holidays that do not effectively benefit them from the point of view of tax revenue collection. And again, there have been many studies that support that this is one part of the story, considering also that the Pillar 2 tax revenue estimation expectations are the bulk of the two-pillar solution. So from this point of view, there are concerns that Pillar 2 is prioritizing tax incentives that are usually used by developed countries and not developing countries. For example, tax credits that require the payment of the return of taxes, whereas tax holidays are disincentivized. And of course, there have been many concerns raised by especially African countries regarding the complexity of these rules, which is an implementation hurdle, of course. And this, of course, creates considerations as to how much developing countries will benefit from Pillar 2 potential revenues, tax revenues. So those two solutions, proposals, Pillar 1 and Pillar 2, even though the OECD was persistently trying to produce arguments of how developed countries will benefit from them, effectively, the arguments were that these proposals were not designed for developing countries, but were designed and effectively would benefit mostly developed countries. So that, in combination with how the inclusive framework, the inclusive framework was criticized both with regards to procedural aspects, but also its role in effectively setting the agenda, created a lot of tension as to whether the OECD was the appropriate forum to represent everybody's interests and to also represent this multipolar world. So this started creating this rising discontents and eventually led to the shift to the UN. But at this point, I would like to make this additional comment, that we usually consider the UN shift, and that's my special contribution to this discussion. We usually consider this shift to the UN as a pure manifestation of this discontent that started in the inclusive framework and was accelerated, exacerbated because of the two-pillar solutions discussion. Nevertheless, we tend to consider that there are these two very distinct blocks between the OECD member countries and the inclusive framework member countries. Nevertheless, we've seen that even member countries within the OECD or the global north, if we want to describe it like this, or within the G20 that became the political representation of these discussions, there was not a uniform position. First of all, the US was always distancing itself from the pillars. With regards to Pillar 1, the US was always very protective towards the US tech industry. And we have seen various expressions of this protection, either through retaliations, retaliatory tariffs against the digital services taxes, or through the negotiation path. Initially, they wanted to introduce a safe harbor, which was not accepted, and then eventually they achieved the broadening of the tax base to cover not only digital companies, but any big multinational. And with regards to Pillar 2, even though the democratic presidency was more positive or was more active in the negotiations, we've seen recently a very negative and hostile approach to Pillar 2 because of voices around how it is a job killer and how it benefits China. So the general consensus is that there will not be any support from this part of the world. And of course, the general discussions around UTPR and whether the threat that there might be retaliations against countries that introduce UTPRs. And of course, in this complex situation, China was also playing a specific role. As we've seen before, China has risen as a significant economic power and political power. So as part of the discussions, the international tax discussions, it was usually not expressing very clearly its position. So it was trying to compromise between, on the one hand, inclusive framework, developing country interests, on the other hand, G20 or OECD member countries' interests. So it was mainly playing the game of the minimum loss for itself, for its interests, but at the same time without setting any specific agendas. So we've seen this fragmentation happening in the OECD, at the OECD level, when the discussions were exclusively happening at the OECD level. And that's the landscape that eventually led to the UN shift, to this shift to the discussions at the UN, or to the initiation of this shift, with the African group being the leader of this initiative. So, having described this landscape, we can see now three groups of countries, of actors, and how they reacted to this multipolarity, rising multipolarity international tax. And I will, of course, try to understand and examine these reactions through the lens of multipolarity. So the first is what I call the establishment reaction, which we could say is expressed by the OECD countries, or the global north, if we want to expand further. So the establishment reaction is that the status quo in international tax, in the international tax governance and regime is fine. There's no reason to reconsider, to challenge it, and to try to rebuild it. And the general narrative behind this idea is that everyone benefits from cooperation in taxation, which is what I already called the positive sum game, that everyone has some benefits. Maybe not everyone has the same benefit, but everyone benefits in the grand scale of schemes. And on the other hand, they recognize that globalization and the liberalization of trade flows and capital flows produces winners and losers, that these are within each economy. So we're talking about domestic inequality, not international, between country inequality. So they make this distinction between country inequality. And of course, by doing this distinction, they limit what international tax can achieve. By looking exclusively at within country inequalities, they claim that international tax is not looking at within country inequalities. This is a matter for domestic tax policies. And that was the reason why the BEPS project was initiated, or that can be an argument for that, because effectively European countries that form the bulk of OECD member countries were starting to feel threatened economically, financially, and they wanted to protect their domestic tax revenues, not only from rising economies, emerging economies, but also from the US. And that's part of the reason why the Action 1 and later Pillar 2 was introduced. So there is this distinction, and unavoidably, this distinction limits the possibilities of international tax. So we are only talking about what domestically each country can do with its tax policies, with domestic resource mobilization, or with capacity building measures to address inequalities within the country. On the other hand, international tax is not concerned with between the country inequalities, because it is not producing these inequalities, it is not deteriorating them, since, as I said, there is a serious positive sum game that everyone benefits. So it is not actively addressing them. It is beyond the scope of international tax to deal with redistribution, global redistribution. So departing from this point of view, the establishment reaction to multipolarity was initially to establish the Global Forum for Cooperation and Exchange of Information. And as I said, of course, the inclusive framework, which came as a reaction to concerns and criticism against the OECD that is not, it cannot implement a global tax reform project without including all countries in that project. So that was the way the OECD was trying to address multipolarity, to address all these rising powers that were trying to claim a voice in the table, a seat in the table. And of course, the G20 was one of these reactions as well, because it expanded the role of non-OECD countries to especially the setting of the political agenda. But as I said before, these initiatives were criticized as unable to accommodate the multipolar world order because of both procedural and substantive concerns. Moving on to the second reaction, which is what I call the critical reaction. So this comes from those that were critical against the OECD, both countries and, of course, voices, academic voices or policy voices. And what the critical reaction is looking at is this shift from the within country inequalities to between country inequalities, and the position and the role of international tax in addressing these between country inequalities, either by acknowledging that it is playing a role in creating them, or by actively trying to minimize existing inequalities that have different reasons for being in place. So it looks beyond the confines of national economies, and it is concerned with how the international community uses international tax to address the redistributional considerations of international taxation, international tax norms. But here again, in the critical approach, the critical reaction, there are different perspectives. And I identify two of them. The neoliberal perspective, which is mostly looking at the procedural element of the previous status quo, of the dominance of the OECD. And the criticism, of course, is, as I said, was focusing on the procedural fairness and, as a result, the legitimacy of the OECD to implement this global project without the participation of everyone. And on the other hand, we have the neorealist approach that is focusing on the distribution of powers and is looking the world as a zero-sum game where my loss is your gain, effectively. So this creates this zero-sum outcome where what matters is relative gains rather than absolute gains. And the neorealist approach is looking at how new powers emerge and what is the impact of this emergence on the international tax governance. So depending on which approach someone follows, there are different expectations that are created from the UN shift. And this is, I would say, the most important aspect of my argument of how multipolarity and the approach taken in multipolarity can give us different answers in how the UN project and this initiative will effectively proceed, whether it will be consequential or not. So, as I described before, the neoliberal approach starts from this perspective of seeking procedural fairness and inclusivity and legitimacy. So from this point of view, someone could say that the UN could satisfy this demand for inclusivity because of the participation of all countries. With regards to procedural fairness, this is, of course, one of the main questions on how procedural rules will be decided. But the idea behind the neoliberal approach is that having these discussions at the OECD, at the UN, is the main starting point of having everyone on the table and deciding on every single aspect of this conversation. On the other hand, the neorealist approach that is focusing on distribution of powers is interpreting this shift to the UN not as a reaction to criticism against the OECD with regards to procedural fairness, but as the outcome of the decline of some of the existing powers, especially the US. And at the same time, the emergence of other new powers, which is what I was describing before. We've seen these new superpowers like China, India. Some African countries are very dynamic economically, culturally, but also regional powers that start to become more influential, not only regionally, but also internationally. So from the neorealist point of view, that's the main reason that could be, these are the lenses through which we can interpret this shift from the OECD to the UN. And this, of course, approach and this interpretation can say a lot about whether this project will succeed or not. And finally, we have the hegemon reaction, which is describing effectively the reaction of the US in multipolarity pressures. And this warrant is a special consideration because it provides this contrast to how the US used to operate, function internationally, how now it's retracting and becoming very focused, domestically focused and aggressive and hostile externally. So the idea, the approach from the OECD, from the US towards the multipolarity and the emergence of these new powers is the isolationism, that international economic agreements are the problem, because the US is claiming that they share the benefits of globalization with other countries, and especially China. So that's to the benefit of China and not the US. And we've seen recently many manifestations of this retraction and minimal cooperation approach. For example, the imposition of tariffs or the threats for countermeasures against countries with the UTPRs or DSTs. And finally, of course, the abandonment of the UN negotiations, and as well as other global forums of discussion. So finally, I wanted to close with some observations of why I'm using this multipolarity framework and what is the benefit of looking at these new developments of the international tax governance from the multipolarity point of view. So first and foremost, it gives us a perspective that international tax governance doesn't happen in a vacuum, but it is happening across other global governance matters. And to some extent, that is the benefit of having the discussions at the UN, that this shift is representative of how tax governance interacts, coexists with other global governance dynamics. And so tax discussions would happen next to climate change discussions or human rights discussions. And the impact of these conversations on taxation matters will be unavoidable. That's one element, that it gives taxation matters and also the tax community, either policymakers or academics, this new way of thinking about taxation in this context. Someone would say a new epistemology about taxation that is part of international law, even though usually international tax is not necessarily approached as an international law topic. And then multipolarity is asking us to question whether, as I said, this move to the UN is a promising shift, it's a consequential shift that will bring changes, or whether it is more or less a shift to a new battleground. So moving from the OECD and the inclusive framework, differences, competitions, and discontents, to a new forum that is equally expressing the same discontents. So having the approach of the multipolarity and thinking of the international tax governance framework as a framework that can express these new different powers leads us maybe to the latter scenario, that we are effectively looking a shift to a new battleground, and not to a new forum that will achieve more cooperation. And in this new battleground at the UN level, there are, of course, considerations of whether these new superpowers like China, India, Russia will accommodate developing countries' interests, or whether they will marginalize them even more, whether there will be this solidarity, and whether they will play the role of representing developing countries' interests, or whether they will focus only on their exclusive interests. Then there's, of course, a question of the regional powers, as I described them before, which is these like-minded countries that are usually, most of the times, also geographically related, whether this development and whether the UN will allow these regional powers to flourish, and what will be the impact, of course, on cooperation, whether this will mean more cooperation at the regional level and agreement on specific aspects, substantive aspects, or whether this will create more fragmentation and will underline the differences in the UN.
Vasiliki, just one quick question on that. In your point of view, do you consider multipolarity as an opportunity or as a threat for global tax coordination, and particularly for countries in the global South or South America?
Yeah, so I think it's difficult to express a specific opinion at this point. I would mostly describe those two opposing scenarios and abstain from having a clear opinion, because I think everything is very early on at the stage of negotiations, and regardless of what is going to happen in any case, I tend to be more pessimistic, because in my point of view, the UN forum will function as I say in my presentation, as a new battleground that will provide the forum, the avenue for all these different powers to express their opposing interests. But having said that, I consider that so far the initiative has been led by African countries, which they also constitute a regional bloc, and they have this, of course, sharing interests among themselves. And because of that, and because of the historic position of the UN as the forum that was trying to protect developing countries' interests, there is, let's say, a force until now that the UN is trying to create this new forum where political views will be expressed and not just technical positions, as the OECD used to do. And in this forum, it will the purpose of this forum, at least at this stage, will be to allow these regional blocs, either African countries or Latin American countries, at least to have a voice on these matters. But the extent to which these different positions will lead to more cooperation or to developing a substantive framework that will be followed and achieving some progress on international tax matters, I tend to be more pessimistic. So to me, it seems like the UN will be this forum to discuss issues and potentially to mandate some more concrete decisions to regional forums, regional organizations, including the OECD, rather than to itself make these decisions.
Yeah. Okay, great.
Yeah, thank you so much for this question, because I have reached the end of my presentation. So
okay, perfect.
That gave me the opportunity to share some of my thoughts, which are
your
very
thoughts.
preliminary.
Yeah. So the last question, because this is interesting for the Global South bloc, if you like, right?
Yeah.
Do we have any way to assert or leverage our tax policy preference? Because we see in the African bloc, they're going in together, right? LatAm countries usually are not viewed as a bloc in tax policies. We're usually a little bit dispersed, right? Do you think that we should, this is like wishful thinking, I know, right? But do you think we should have an action as a bloc in order to assert some kind of leverage in traditional forums are usually dominated by developed countries, right? But here it appears that we have an opportunity.
I agree with you that this is an opportunity, and thank you for asking me, not being in the region, about my position. And I think I would like to know your position rather than contribute my point of view, because I would guess that's a very interesting point, that you consider African countries to be more homogeneous and working as a group, at least from an outsider's point of view.
Yeah.
Equally, I didn't know that this is not the case in LatAm countries. So again, as an outsider, I do not have a specific understanding of whether you are less homogeneous. Maybe you are at an earlier stage of cooperation. I know there have been some developments in the area of tax cooperation in LatAm countries. Maybe there are historic reasons or political reasons. You prioritized other parts of your political agendas, and that has become less of a priority.
Yeah.
But to some extent, and to the extent that there are common economic interests, solidifying them through an organization, a policy organization, and representing them as a bloc in a forum that promises to be a political international forum for these discussions is, of course, an opportunity.
Yeah. Okay, thank you so much for your views. On my end, I do think we are a little bit dispersed or non-homogenic, or not as much as we would like in order to assert some kind of leverage in a forum that is much more political than the forum that we're used to deal with tax policies, right? So I think that's going to be a shift of mind on how we approach our intervention on those forums. Thank you so much for your presentation, Vasiliki.
Thank you for the invitation.
Very illustrative. Now we're gonna go ahead. Gonzalo, you wanted to chip in with some comments on the UN forum and the OECD and how we should probably act as a bloc, right?
Oh, yes, we were talking earlier about that. Even though they start to have some sort of connections between at the level of the checkers ministers, they don't the interest and the system of all the South American countries are really different. You have on one from one side Mercosur, that is a loosely connected bloc, but they are not as integrated. Their system are really different, and they have really different problems. The Brazilians and the Argentinians, they want to simplify their tax systems because it's kind of nightmarish especially in the indirect taxes. They have a lot of problems with that. And Brazil took this seriously, and they have implemented a long-term reform to modify all the indirect taxes. Argentina wants to do the same, and in both cases, they don't really. Usually, they don't think in the region. They usually are kind of big countries, so the only kind of cooperation that they have is real cooperation is at the level of the tariffs. And on the other hand, we have the Andean Pact that is based on this territorial taxation. So you have Bolivia, Peru, and Colombia, and they also have this kind of tariffs, uniform tariffs, but in both cases, the integration at the level of taxation is minimal. And Chile, we have this kind of multilateral. We are not in none of these blocks, so it's really hard to think that the work that the ministries of the chancellors of the exchequers are doing right now, because it's kind of political. So and they are not fixed on the tax conventions, but the work that they have done until now is just concentrated at the internal level. So I think it's kind of hard to, or we are not seeing right now that they are some sort of coordination at the level that Vasiliki is talking. So they are concentrating in a different issues.
Yeah. Thank you so much for your input, Gonzalo. Now we are gonna go ahead with our final panelist that Lucas hasn't arrived just yet. Maybe we can stop for a coffee, everyone, while we wait for Lucas to join in. Thank you.
We'll be back in like 10 minutes.
Yeah.
Hi, everyone.
Hi, Lucas.
Let me just check if I can hear you. Just a second. I think that this is my headphone. Just a second. Here it's okay. And then this. Can you
We
speak
can hear
again?
you.
Yes, now I can hear you. Hi,
Okay,
Maria.
perfect. Hi, how are you, Lucas?
I'm fine, thank you. How has the event been so far?
It's been really good.
Great.
You were just on time, so perfect.
Excellent. I'll just turn on my camera. Do I share my slides? Can I share my slides with you?
Yes, you can go ahead and share your slides.
Okay.
So I'm gonna briefly introduce you. So our final panelist is Dr. Lucas Carvalho, right? Carvalho? Is
Yeah.
it
You can
Carvalho?
call me Lucas Carvalho, Lucas de Lima.
Okay, you have
Yeah.
multiple names then.
Yeah, just two.
Lucas earned a PhD in economic and financial law from the University of Sao Paulo. And you are also a LLM of NYU, right? Of International
Yes, I am.
Taxation, right? An MBA
Yes,
from
that's true.
Fundación Getulio Vargas. You are
Yes,
also the founder of the Latin American Tax Policy Forum. So
it is
congrats
true.
on that. And you're usually a regular contributor of the Tax Notes International, right?
Yeah.
So we're gonna talk about a little bit of QDMTTs in Latin America context and Pillar 2, right?
Yes, that's
Okay,
exactly it.
awesome.
Let me
So
just
let's see if we can see your presentation and we
let me
can,
see if we can let me see if I can share it in just a second. So I'll
sure.
share it. I'll share the screen here, and you're probably seeing it now. And if I do
Yes,
this, you should probably see the whole screen,
that's
right?
right. That's right.
Okay.
Great. Thank you.
So perfect. Let me just see here if I can do I'll share the screen here. And then if I change the slides, you can see it? You can see the
Yes,
changing of slides? Okay.
yes, we
No,
can.
that's the important bit.
Yeah.
So I'll stop the share right now. I'm just going to get the second screen set up, but you can introduce me and then we'll
Go ahead. Perfect.
perfect.
So we are currently, Gonzalo, are you there? We're currently live. So whenever you are ready, Lucas, we can go ahead with the presentation. Okay. So here is
Perfect.
Gonzalo. Yes.
Let me just get the thing
The
with
second screen, don't worry, we have time.
yeah. I'll get the second screen here and then yep. And I'll send it to my myself here. How many people? How many people are joining us?
So we are currently on this Zoom. There is just the four of us, and then we are live streaming via YouTube, the Universidad de Concepción channel. So I don't actually know how many they're connected right now, because if I change to YouTube, then it's gonna activate and nobody's gonna hear anything. So
No, it's okay then. I was just thinking, how many people were following through because it's a long program. It's
yes,
four lectures, one after the other, which is
yes,
why I planned to do a little bit different with one. I'll get the tablet just a second.
go ahead.
All right. Perfect. Get the thing and this. Accept. Okay. So, thanks. Mode. Perfect. I will
Okay.
now share. I'll share the screen again.
Perfect.
And by sharing the screen, I will put it here, share, and slides. Wonderful.
Perfect. Okay, thank you, Lucas. So, welcome everyone again. As I was saying, Dr. Lucas Carvalho, he's a PhD in economics and financial law from the University of Sao Paulo, international taxation from NYU LLM, an MBA from Fundación Gertulio Vargas, and you also study at the Chinese University of Hong Kong. Wow. Okay, so Lucas is the founder of Latin American Tax Policy Forum and a regular contributor to the Tax Notes International. So as of right now, the floor is yours, Lucas. We are keen to hear your presentation. Thank you.
Thank you very much, Maria. Thank you, Gonzalo. Also, Marcelo, I see that is in the call, so the video conference. So thank you very much for the kind invitation and to this very prestigious event. This is my first time speaking at a conference hosted by Universidad de Concepción, which is an honor and a privilege. The Latin American Tax Policy Forum has recommended articles in the Revista de Derecho Tributario to its members for some time, and we hope that we will continue to be able to do so in the future. In fact, we have recommended one article about beneficial ownership written by Maria to our members. And I checked this earlier today, and in the curated section of LATPF, we have links to 19 articles written or co-written by Gonzalo. So of the
Yes.
nearly 3,000, Gonzalo, 19 are yours. And I hope that more people read your work and more people read Maria's work and cite you and exchange ideas with you across Latin America and beyond. So if any of you watching are interested in supporting our mission to facilitate the exchange of ideas between Latin American tax policymakers, please consider joining LATPF as a member by visiting our website, latpf.org. This presentation is about the QDMTT and some tax policy considerations for Latin American countries that have either implemented it, like Brazil, and also Colombia, but not as a qualified minimum tax in the case of Colombia, and for countries that have not implemented it yet, like Peru, Argentina, Chile, Mexico, and others. That said, if I'm not mistaken, in Chile right now, you're 1 hour behind me, yes? So this is, now it's like 12:52 in São Paulo, so you're probably 11:52.
That's right.
So if that means that this conference, if this conference is scheduled between 9 a.m. to 1 p.m., the people that are watching me have been watching some other excellent presenters and panelists before me, and you're probably tired of listening to people talking. So what I'm going to do is I thought of doing something different. I'm going to remain in silence for the next 12 slides. It's a difference, a bit of, it's un experimento pedagógico. But it's going to be a little bit different because I want you to read what's in the slides.
Okay.
And then I'm going to start talking at slide 13. So let's go through the first slide. I'm just going to pass through the slide. I'm going to read them with you. And when I feel that enough time has passed, maybe half a minute, I'll pass to the other slide. So let's start with the first slide.
Okay, just 4 countries in the middle.
One of them, Chile. Let's go to the next slide.
Good. 5.4%.
And the next slide.
"70 did not attend a single working party meeting." Really? Wow. I like this pedagogic experiment of yours, Lucas.
Yeah, just for people to see it and take it all in. Take it all in. Just think about what you're reading right now. Let's go to the next slide. And then
Okay.
the next slide. And then
Colombian.
and also and here is a
Right.
bonus round. Just because of what the representative from the Brazilian government said, following international standards. And here's where those references appear. As you can see, many different kinds of tax rules.
Yeah.
This is in Brazil alone, just in Brazil. And now
In every other LatAm country.
all I'm going to say about these slides is that Latin America has been an importer of tax law and policy for a very long time. When Pillar 2 was presented to us in 2019, it was presented as a foregone conclusion. It was just an obvious evolution of global tax policy. And when the OECD announced that more than 130 countries agreed to the two-pillar solution in 2021, the message was that this was going to happen, whether local constituencies wanted it or not. It was going to happen. And you can apply this to a lot of other kinds of best practices and international standards, but perhaps none of which with the strength and the interconnectedness of Pillar 2. Because if one country does not apply Pillar 2, other countries might apply the rules of Pillar 2 on the profits that were earned by that country's entities locally. So if you're familiar with the rules, and I imagine that the prior presenters of this wonderful seminar might have talked about the rules a little bit, but if you're familiar with the rules, that's how they operate. They operate in such a way that if Chile, for example, never implements the globe rules, none of them, not the QDMTT, not any of them, what happens is other countries can step in and impose a top-up tax on profits that they believe Chile has undertaxed. So it's not about Chile's own sovereign tax policy decisions anymore. It's about what other countries, what the community of countries in the inclusive framework believes the right amount of tax should be. And as I said in a previous presentation earlier this month, I think, the threshold of 750 million euro is a mirage in the sense that that's how it applies today. But if many countries implement the globe rules, and if many tax authorities are used to the application of globe rules, what's going to happen most likely is that that threshold is going to be lowered from 750 to 500, maybe to 250, maybe 100, maybe even 1. It all depends on ease of compliance, ease of tax administrations working with the globe rules, and the impact of those rules on day-to-day multinationals' activities. So I'm just bringing to you those bits of information, and I think most importantly of all of the slides that I've shown is the statement by Pascal Saint-Amand about equal footing, which is something that is in a book written in French. So if you don't speak French, a lot of people will not have caught that statement, but I translated it to English for people to read it. And it for me, it was a pretty perplexing admission, but probably not for him because he was thinking of it in diplomatic terms. But in terms of fairness and representation and how those things are sold to us, it's very interesting to read what the man behind the project says about the project. And you will hear this. You'll see this in legislative debates. You'll see politicians, even from developing countries, saying that this was a project that was designed and organized on equal footing between different countries in the region and abroad. And this is just a slogan. This is just a slogan that was used to attract countries. And the most important reference for me was when he says to attract countries to sit around the table where decisions against their interests were being made. So it was decisions against their interests. Why are we deciding all of a sudden that this is important for us and this should be implemented by us? But that's going back to the reference made by the Brazilian government representatives. Those are the rules of the game. A game that we have not started, a game that we have not organized, but we are being, let's say, compelled to play. And again, this raises a number of tax policy questions that I hope I will address in this presentation. But going to the QDMTT itself, I'm sure that you're by now familiarized with how the rules work. But essentially, you have to find out whether you have an in-scope group for purposes of the QDMTT, for purposes of the globe rules. If you do, then you have to allocate income and taxes between the entities of the group. And that's an important exercise because, for example, usually the income earned by a permanent establishment will appear in the financial statements of the main entity, even though it was earned by that permanent establishment. And the rules treat a permanent establishment as a constituent entity. So you have to allocate that income back to the permanent establishment for purposes of the globe rules. The same thing goes for taxes. The CFC taxes imposed by, for example, Brazil, here in the example on the revenues earned by Peru, if Peru had earned revenues or profits, more precisely on the income earned by the Peruvian entity. If Brazil imposes a CFC tax on those profits, the globe rules say that you have to allocate the CFC rules of Brazil to Peru. So Peru's taxes will include its own taxes plus the taxes imposed by Brazil, because those taxes refer to the profits earned by the Peruvian entity. So you have to allocate income and taxes between the entities of the group. And three, you have to calculate taxable base for purposes of the GloBE rules. Now, this is an exercise that a lot of us know because we deal with corporate income taxes in our respective jurisdictions. In Chile, I'm sure, you start by looking at the financial statements, like we do it in Brazil, and then you start making subtractions and additions. You add some expenses, you subtract other expenses. For example, if you have accelerated depreciation, you have to subtract from the net income amount, considering what's in the accounting statement, because the accounting statement will only have allowed for a defined depreciation amount, and you, per local law, allow that depreciation to be accelerated. And also you have to make all kinds of adjustments to make sure that this is accounted for in the future. So you make those adjustments to arrive at what we call the GloBE income or loss. This is an exercise that starts at the level of the entity and then is added for all the entities of a jurisdiction to arrive at the total amount of global income or loss for that jurisdiction. And it's very important to know that the rules are different from your local corporate income tax rules. For example, the GloBE rules state that you can only deduct a fine or penalty up to the amount of 50,000 euro. But that might be at odds with your local legislation because, for example, in Brazil, you're able to deduct certain fines to the full amount of those fines if they are, for example, for missing a report or not filing a tax return, and if the consequence of those actions is not a deficiency in tax payment. If it is not a deficiency in tax payment, the fine associated with that formal obligation can be deducted for tax purposes in Brazil, regardless of the amount. But for GloBE rules, if it is over 50,000, you cannot deduct it. So that's different from what we do in Brazil. And essentially what that means is that you have to juggle now 3 sets of documents: accounting documents, local tax documents, and GloBE documents. So this is just one example. There are others. There are debt forgiveness, for example, debt waivers. For GloBE purposes, the only kinds of debt waivers that are considered deductible are those that are given to entities in a situation of significant financial distress. So if the entity is completely unable to pay for its debt, to pay for its obligation, then in those cases, like bankruptcy, like, you know, the net equity is so low, it's negative, and you have no money left, and in those cases, for GloBE purposes, you can deduct it, but for other cases, you cannot deduct it. Well, some countries might view it differently. Some countries, for example, Brazil does not allow you to deduct debt waivers. Other countries might allow you to deduct some, maybe not others. Other countries might allow you to deduct all kinds of debt waivers. All that I'm saying is that the exercise in step 3 is not the same as you will have in the preparation of your local corporate income tax. So that's an important thing to take into account. Now, on step 4, you will do the same exercise before the taxes. So step 3 was about income, taxable income for purposes of GloBE. Now you will have to calculate the adjusted covered taxes for purposes of GloBE as well. These are usually taxes on income, but there are other categories as well, but usually the taxes imposed on corporate income. And then you have to calculate those taxes. One thing that you might consider important in that calculation of taxes is the calculation in accounting documentation of deferred tax assets and deferred tax liabilities, which will have an impact in the total tax expense for the period. There are specific rules in the GloBE model rules to handle that, which is, they are in Article 4.4. So for example, deferred tax assets, you can only calculate them up to the percentage of the minimum tax. So for example, in Brazil, the aggregate corporate tax is set at 34%. For GloBE purposes, a taxable loss that is incurred in the previous year can only be registered as a deferred tax asset in Brazilian accounting in Brazilian accounting, it can be registered at the full amount, 34%. But for globe purposes, it can only be booked at 15%. It caps at 15. The opposite thing happens with deferred tax liabilities in the sense that you have to pay for those liabilities up to a certain point in time. So it's not a rate limitation per se, it's a time limitation. If you book a deferred tax liability, by its own nature, what you're saying in your accounting statement is, one day in the future, I'm going to have to pay this tax. I know that I'll have to pay this tax. The event that makes me pay this tax has materialized. I'm going to pay it in the future, but not now. So I'm going to book in my accounting documentation, my financial statements, I'm going to book a deferred tax liability. If you don't pay for that liability in up to 5 years, you have to go back to the first year, the year in which you booked it, and you have to reverse it for globe purposes. So that's what I meant when I said you have to juggle 3 separate kinds of documents at the same time if you're a multinational entity within scope. Then you go to step 5. When you have those 2 numbers, when you have taxes paid and we have the income that you earned for that year in that jurisdiction, you add all the taxes paid by all of the entities of the group in the jurisdiction, and then you add all of the income earned by all of those entities in the jurisdiction, you divide one by the other, and you find the effective tax rate for globe purposes. If that's 15 or above, that's the final step. You don't have to do anything else. But if it's below 15%, then you go to, I would say, step 5.2, which is you calculate the top-up tax. And the top-up tax is that percentage multiplied by globe income minus what we call the SBIE, which is the substance-based income exclusion. That's 5% of payroll and 5% of tangible assets. Right now, it's above 5 because these are the transition years, 2025, 2026, up to 2027. These are the transition years, but it goes even further than that. I think 2028, you still have rates that are above 5%. But the baseline is it will eventually get to 5% of payroll and 5% of tangible assets. Tangible assets meaning property, plant, and equipment, natural resources, licenses given by governments to operate, roads, and so on. Those would be qualified as the tangible assets for globe purposes. You get the globe income minus that amount, and then you find what is called the excess profit amount. You multiply the difference between the globe minimum rate, 15%, and the ETR per that excess profit, and you find the top-up tax. Then you get to step 6, which is where the QDMTT comes in. Step 6 is where you allocate that top-up tax amount to a country, one of the countries in which the group operates. Now, in this example, you can see the United States, the Netherlands, Brazil, Peru, Japan, and Panama. If the money was originally earned by a company in Brazil, because Brazil imposes a QDMTT, naturally, the first rule that would apply would be the Brazilian QDMTT to be imposed on those undertaxed profits. Now, you could ask me, why would a country that has a corporate income tax have a QDMTT and impose a tax on undertaxed profits? Wouldn't it be simpler to just raise the local corporate tax or eliminate the parts of the tax that give rise to undertaxed profits? That's one way for a country to go forward, one alternative for a country to consider in terms of globe adaptation. But I would say that the problem there is that if you make an adjustment to your entire corporate income tax, that will affect in-scope companies and out-of-scope companies. It will affect companies belonging to multinational groups and companies belonging to domestic groups. Now, for a policy reason, for example, you want to stimulate local growth and you want to stimulate the local industry and so on, you might not want to do that. So because of that, and this is the decision made by Brazil, you have a tax that is specifically imposed on those profits, which are undertaxed for globe purposes. Now, suppose that after Brazil imposes that tax, there's some top-up tax amount left. And then you can ask me, why would there be a top-up tax amount left if Brazil has imposed a QDMTT, a qualified domestic minimum top-up tax? If Brazil has imposed a qualified tax, surely that tax should have covered everything that Brazil owes, or that company in Brazil owes for purposes of globe, right? Right. However, there may be differences, and those may be some material differences between the accounting standards used by the UPE jurisdiction, the jurisdiction of the ultimate parent entity, or the jurisdiction of the intermediate parent entity, and the jurisdiction of the constituent entity. Because of that, Brazil might look at those profits and look at the top-up tax amount and say, I collected everything. Other countries, because they have different accounting standards, therefore they start from a different point in relation to what Brazil starts, they might say, no, 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 you still have some top-up tax amount that you haven't collected. Now, Brazil cannot collect that additional top-up tax because Brazil, under local law, is using its own local accounting standards. Brazil says, I have zero tax left to collect. But other countries will say, well, per my accounting standards, you still have 100 to collect, 200, 500, 10,000. You still have money to collect. If that's the case, you go to the next rule, which is the income inclusion rule. The income inclusion rule operates a bit like a CFC rule, but not really, because it is not premised on control necessarily. It is based on ownership. It is also not based on the level of tax that is imposed offshore being below a certain amount. It is imposed on those entities regardless of the level of statutory tax. We're talking in Globe about effective tax, which is a different concept. But regardless, it's the income inclusion rule. Now, the United States have not implemented the income inclusion rule. They're probably not going to implement one. If they do implement it, it's going to be what already exists in the United States, the GILTI, but qualified as an income inclusion rule. Now, that's a big debate that is happening right now between the United States and the OECD. We don't know what's going to happen in the future, but so far, they do not have an IIR. If they don't have an IIR, then you go to the next country that has a participation in the constituent entity below, and that would be the Netherlands. They would have an income inclusion rule, and they can tax whatever Brazil has not taxed. If there's any tax left after this application of the income inclusion rule, then the undertaxed profits rule kicks in. And that's what Japan has implemented, and is a very controversial rule that is not the topic of this presentation, but it's a controversial rule because it basically requires a local Japanese entity to pay tax on profits that it did not earn. It has no control over the entity that earned those profits, and it cannot compel that entity to pay dividends, so that with those dividends, it can pay the tax to the Japanese authorities. So under any basic ability to pay standard, which is the bedrock of democratic rule of law, and so far as it comes to taxation, you should not be able to impose that sort of rule. And some courts have already been asked about this, especially the Belgian court in relation to the UTPR of the European Union. But other courts, if the UTPR becomes mainstream, and I doubt that it will, but suppose that it does, you will see more challenges against UTPR in the future. And some reputable scholars have made contributions and commentary and written a lot about the reasons why the UTPR should not work from a global tax perspective, international tax policy perspective, and so on. So that's how the rules operate. And I went through this because even though you might know how the rules operate in the globe space, I just wanted to show you where the QDMTT enters into the picture. And this is where it is the first rule of the globe rules that is imposed on profits earned directly by a local entity. A qualified domestic minimum top-up tax, it's of up to 15%, and it depends on the ETR of the M&E group in the jurisdiction. It was not a part of the 2019 program of work. At the time, it was questioned by some developed countries because they said, look, you're giving the money back to the tax havens, for example, that have not imposed a sufficiently high corporate income tax. Why are you doing that? You shouldn't do that because it should be money given to us, the places where the controllers of those companies are located. And at the end of the day, it's all about money. That's where the Pillar 2 discussion started. That's how it has progressed. It's all about money. It's not about making sure that multinationals pay a fair share of tax on their profits. It's about making sure that they pay a fair share of tax to me. It's not a fair share of it for all the entities. It's a fair share for my jurisdiction. And this is mostly European countries. You have to remember, most of the members of the OECD are members of the European Union. It is not a surprise that the rules that are produced by the OECD or are discussed and produced between the OECD and the inclusive framework have the sort of fingerprints of the European Union representatives. And the important part about the QDMTT and the other rules is that what it's all about is not, for the countries, it's about money. But for the OECD, it's not about money so much, it's about influence. The more the OECD is able to make the rules widespread, the more we'll rely on them for the calculation of that minimum tax. And then courts will start to apply those rules, and it will start to become something that is usual, common practice, and discussed and implemented by all countries, whether they are Latin American countries or countries in other parts of the world. This is what happened with the transfer pricing guidelines. How many countries are members of the OECD? How many countries use the transfer pricing guidelines every day because they operate with players in other countries that do have those rules? And you even have courts, lots of courts, in Brazil and in other places of the world that use the OECD transfer pricing guidelines as a basis for their rulings, even though they're not members of the OECD. This is all about influence from the perspective of the OECD and about money from the perspective of developed countries that have implemented the GLOBE rules and that want those rules to be applied. The GLOBE rules are rules on taxes on corporate profits. Though the taxable base can be different from the local corporate tax. This is something that I have already covered. And also they can be challenged under Article 24(5) of tax treaties that follow either the OECD or the UN model, because the tax treatment here is a tax treatment that is other or more burdensome than the tax treatment given to entities controlled by locals. Essentially, the point of Article 24(5) is, if you have a local entity controlled by someone in your jurisdiction, you should not give that entity a different tax treatment in comparison to another local entity that is controlled by someone in a treaty partner. So you can't do that. And the OECD obviously says, oh, there's no conflict. But sometimes I have a problem keeping myself quiet when I hear panelists say, well, the OECD said there's no problem. And then they move to the next slide. I say, well, of course the OECD says that there's no problem. Imagine if the OECD had created rules for the taxation of corporate profits, and because it's important that they have a global minimum tax. And imagine if they have created those rules and they say, but Article 7.1 will be a problem for the imposition of those. Of course, they're going to adopt the position that there's no conflict. And what is their argument? Their argument is that the reason for the differentiation is not the residency of the investor. The reason for the differentiation is just because the entity belongs to a multinational group that is in scope for global purposes. So the discrimination here is not based on residency in the tax-free department. It's not because I'm not imposing a different tax because that investor is resident in China, and therefore I want to tax this person differently because I don't want the Chinese investment into my country for some reason, or American investment, or German investment. That's not the reason. The reason is because we have a multinational entity in scope, and therefore we tax them differently. But again, that's a very debatable issue, and I'm sure that this is going to arrive for local courts to analyze soon enough. And it is subject to a peer review system for qualification. So again, this is what I used to compare this to was suppose that you have an online shop and you want you want to bring in clients to your online shop. It's hard out there. You have to sell your product at a, with a good profit margin, but also at an attractive price. What you do is you start selling smartphones, for example, at a reduced price because you want to attract more customers. And then suppose that all the competitors in that space, all the other smartphone sellers, tell you, look, we're going to let you charge your price, but your customers are going to be charged on their credit cards for the difference between your price and what we believe is a fair price. So every time someone buys from you, they're going to have to pay an additional charge in their credit, and that's going to be debited regardless of what you do. Regardless of what you do, we're going to charge it. Then your clients are going to say, well, if someone's going to charge me for the difference, maybe I'm not going to shop in your online store anymore. Because the only reason that I considered purchasing from you was because of that price difference. Now, if that price difference is compensated and then you can't sell those smartphones anymore, then all of a sudden you, a developing country, trying to attract investment, become even more developing because you can't attract investment using the same tools anymore. And the countries that tax the difference, you can imagine, for example, the IIR countries are countries that are known for their capital exporting status, meaning that those countries already have the structures in place to attract multinational entities. They already have development and security and infrastructure. And those countries are leveraging those aspects of their jurisdictions to collect even more money. At the end of the day, for those jurisdictions, it's all about money. This is a figure, this is a graph that you get from a report from the Inter-American Development Bank. And this report shows the difference between statutory rates and effective tax rates in Latin America, OECD, and other countries. As you can see, Latin American and the Caribbean impose some, high taxes on local companies. So 24.1 is the statutory tax rate on average between all the countries in the region. It's even higher in terms of effective average tax rate, which is 23.9. This is the rate, the middle column. This is the rate that matters for purposes of GLOBE, because these are the tax amounts paid by multinationals in deciding what we would call routine projects, whether they make an investment or not, because they are bound to be profitable in those investments. So those are just your day-to-day regular business activities. And you're going to earn a profit anyway. You're just deciding what project you're going to pick to expand your business. But the effective marginal tax rate, which is lower, 13.8, still higher than the other countries and the OECD, far higher, is for the marginal investments. So those investments in which you're not sure you're going to make a profit, or if you do make a profit, it is also based on paying little tax. So even in those situations, the Latin American countries and the Caribbean countries impose a tax rate that is superior to what you would find in OECD countries and other countries. Of course, this is an average. So if you think of Caribbean countries, some of those countries either don't impose a corporate tax or impose very little corporate tax. Or, for example, impose corporate taxes only on territorial profits, like, for example, Panama. But on average, we impose a lot of tax on corporate profits. So in principle, you would think, well, you know, we understand globe rules imposed on a lot of multinational companies, in-scope multinational companies, but we're imposing taxes on corporate profits in Latin America. What's the problem with us? Why would we worry about globe at all? Well, let me tell you about the case of Brazil. Brazil has implemented the QDMTT late last year. We have a aggregate statutory CIT rate of 34%. There are higher taxes on corporate profits imposed on insurance companies and banking, financial institutions. But the government representatives of Brazil, when they released the provisional measure that contained the QDMTT in Brazil, they said there are 8 million legal entities in Brazil in 2022. Of those, 8,704 are part of in-scope M&Es. 957 are subject to an ETR below 15%. And then you can say, well, how do I reconcile this with this? And it's simple. First of all, that is an average. This is specific, 957 specific entities. And second of all, Brazil has some very accommodating and interesting tax incentives in its system. For example, Lei do Bem, it's a tax incentive for R&D income. We have tax incentives for income tax for projects in the Amazon and the northeast of Brazil. And we also have some special regimes of corporate tax profits. So for example, there is one of those regimes called lucro presumido, is a regime that allows you to pay a tax of, if you're a services provider, it gets to around 10.88% of your total corporate income tax charge, 10.88%. That's low compared to the 15% of the globe rules. So there are some entities that will be subject to those rules. And the argument said in Brazil was, if we don't impose that tax, other countries will impose it. That was the argument. And for many people that have no knowledge of the globe rules, that have no knowledge of international tax or tax in general, if someone from the government says, either we impose those taxes or someone else is going to collect them. If someone from the government says, we need to impose those taxes because it's better, this was said by government representatives in Brazil, it's best for us to get those tax revenues and use it to pay for schools, hospitals. This was said by the government representatives in Brazil when they announced the QDMTT rules. Schools, hospitals, roads. It's best for us to do that than for us to let other countries do it in the world. And first of all, this is not necessarily true. Why? Because one, not all countries are going to implement the globe rules. Second, if some countries implement the globe rules, some of them are going to implement QDMTTs. And the QDMTT is applied on locally earned profits. Locally earned profits. So it's not applied on profits earned by foreign entities. So if all of the entities in the example that I presented had QDMTTs, the local governments would worry about locally earned profits. They would not worry, for example, the Peruvian government would not worry about Brazil's profits. The Japanese government would not worry about Brazil's profits. They would worry about local profits. So it's not true that if Brazil doesn't tax it, someone else is going to tax it. And also, and this is something that we're seeing more and more, these rules can be questioned and challenged before local courts. So it's not necessarily true that if a country has implemented an IIR or a UTPR, that this rule is not going to be challenged before local courts. And here I brought sort of a list of a few tax incentives given by other countries, Chile among them, but other countries like Colombia, Argentina, you have Panama, you have El Salvador. El Salvador is a very, very aggressive tax regime for companies in the tech industry, which is something that at the time when they announced it, it was 15 years of zero income tax on those projects, on the revenues from those projects. That's pretty aggressive, but they're not, you don't see El Salvador participating in those discussions. El Salvador is not even in the inclusive framework. So take that into account. El Salvador is not even a member of the inclusive frame, like Ecuador isn't, and other countries are not. But it's something to think about. So you see here, the OECD published this document. I encourage you all to read it. It's a document about the what's going to happen with tax incentives in a world with the QDMTT and the IR, the UTPR. And then they go through some types of tax incentives, like, for example, expenditure-based. That would be your accelerated depreciation. That would be your investment allowance. That would be those tax incentives that are linked to specific revenue streams or specific assets. And because of that, they're not affected by the globe rules as income-based incentives would be. So, for example, I think that this is this reference in 2014 is from Colombia. There's an incentive for projects in renewable energies. You have the recent incentive in Argentina, which is an added credit that is given to local entities for investment in Argentina. And it even says there's a provision in Argentinian law that says that the credit is not going to be given if it gives rise to a tax under GLOBE, even though Argentina has not implemented GLOBE rules yet. But there's a provision in the law that's already kind of preparing the country for the possible implementation of that rule by other countries. But you have those like cash grants or refundable tax credits, they are less affected. This but that I added here is because the OECD says they are less affected, but because they require cash disbursements from the government to the companies, they raise revenue risks, they raise budgetary risks, they raise riscos presupuestarios for those entities and for those governments. And so it's important to keep that in mind, because if you're going to just give money away, you just have to make sure that that incentive delivers the welfare gains that are expected from it. And many of those programs, maybe you have some experience with that in Chile, but many of those programs are not followed through. So they are implemented by one government, but then the other government doesn't really check, doesn't really diagnose problems with those investments later on. And there's not as much accountability by the local entities in terms of their commitments into the project. And of course, income-based incentives, those would be your exemptions, those would be your reduced rates. So just pay less tax. In Panama, this regime, Panama is already a jurisdiction that imposes a corporate income tax that is significantly beneficial because it's territorial in the sense that, you know, the foreign profits are not taxed. But you can even reduce that even more if the headquarters of your company, sede de empresa multinacional, are in Panama. And then you reduce it to 5%. So those incentives are more likely to be triggered be affected by GLOBE rules. In what sense? They're more likely to reduce your taxes on top of your income, because your income comes from your accounting income, not your taxable income. So you have less tax paid and the same amount of accounting income. Therefore, you have a smaller effective tax rate, which means that 15% minus this is a huge amount. And therefore, you're exposed to the GLOBE rules and to their impact. This is the last slide. Now, there are some key discussions that we as Latin American tax policymakers and Latin American tax practitioners and academics and members of LATPF and people that are in Universidad de Concepción and other places, we have to discuss, which is, first of all, it's nice, regardless of what the OECD is doing, it's nice for us individually to review the tax incentives granted to local companies by our governments. Are those incentives resulting in welfare gains for our constituencies? If they're not, or if they are way more expensive to give than they are in terms of what they bring back, then it may be the case that, well, it's not interesting for us to keep those incentives as part of our systems. So it's something important for us to keep in mind, like Honduras did recently. They changed a lot of the tax incentives that they had because a new government came into power and they wanted to repeal a lot of the incentives that had been approved by the previous government. But those incentives were absurd to some extent. There were incentives that were in place for 25 years, 30 years. 30 years, an incentive that is in place for 30 years is basically a shackle that you put into the wrists of people, because in 30 years a whole society can change. In 10 years a whole society would change, and then in 30 years you'd still be required by law to be giving an incentive to those companies. So it's something to keep in mind. I think that at the time LATPF sent an opinion paper basically saying, look, we have to be careful not to violate legal certainty, even though it is commendable to review tax incentives. But the three things that I add here is CFC taxes are allocated from the investor to the invested state. So even if Latin America does not impose sufficient income tax, you have to remember that the CFC taxes imposed on controllers in other countries will be, for globe purposes, allocated to Latin American entities. So even if I impose a tax on income that is like 10%, if someone else imposes a tax on income of 15% in addition to my 10, then that additional tax of 15% is going to be allocated to me. That meaning that tax is not going to, that I'm not going to be in a position with a low ETR, therefore not subject to the globe top-up tax. And the two final points, one of them, the QDMTT is a tax on income, so the same boundaries applicable to income tax should apply to the QDMTT as well as other taxes, meaning, if, for example, if a tax is if your local legislation says that fines for non-abusive practices are deductible for corporate taxes, because those taxes are taxes on income, there's an argument to be made that they should be deductible for purposes of the QDMTT. And this is something that local companies should be able to present to the local courts. Say, look, this is wrong, and we should be subject to the same kinds of rules. There's a sort of a constitutional basis behind the income tax that is imposed in each country. That's the way they see what an income tax should be like. And finally, it's the final point there, which is there are gains in harmonizing tax compliance under the GMR, but policymakers should be concerned with the level of authority they are attributing to OECD guidance and whether local courts will agree to it. So it's important for you to keep in mind that there will be situations in which the OECD will change the rules. They're going to change the application of the rules, and they're going to change the way the rules operate in many countries. And if your legislation says that you will adhere to what the OECD says about those rules, then what follows is that you will be tethered to what an unelected external organization says about tax policy, with real consequences for your tax policy making and your tax policy decisions. Now, you can argue that we already do this. For example, with the CBCR, the country-by-country reporting. We follow OECD rules as we do in terms of transfer pricing. What I'm saying is that this is a rising tide. This is a sort of, we're going back further and further inland as the tides of external guidance creep into our own legal systems. And in the case of the CBCR, you're just streamlining reporting of information. In the case of the transfer pricing guidelines, you're just making sure that you have the similar sort of corresponding prices for intercompany transactions. So if there's an adjustment in one country, you just want to make sure that that adjustment is made in your country as well, so that, for example, there's no phantom income appearing in the hands of an in-group entity. And that's a very different discussion in comparison to Pillar 2, because Pillar 2 strikes at the very core of corporate tax, which is the imposition of tax, the imposition of taxes by a local jurisdiction. And if you impose a tax based on OECD guidance, every time they change it, you will change your tax as well, even if you're not an OECD member. And even if you're not an OECD member, I go back to the original question, why are you doing that? If you are an OECD member, like Chile is, my question would be, shouldn't you challenge some of that guidance if it is at odds with your constitutional and legal standards? Shouldn't you be able to have your say on what your tax policy decision should be, regardless of what the officials at the OECD say? And that's perhaps the final message that I leave for all of you, is that in discussing tax policy and tax policy in Latin America, we have to keep in mind that we're discussing a very sensitive topic with people that are interested in collecting more money and preserving their influence and imposing their worldview on many countries, including developing countries. It's not without reason that the UN has progressed somewhat in its discussion of its own framework convention for international tax. What they're trying to do, maybe unsuccessfully, is they're trying to build some sort of resistance in relation to the OECD and in relation to their control of the global tax policy narrative. So if I were to give any recommendation today, I would strongly consider that people entertain the idea of adopting a QDMTT. But know that by doing that, you're giving a lot of power to an external organization, and they have reasons to preserve that power. That's all for my presentation today. Thank you very much for your time and your kindness and your attention, and I remain open for questions. Thank you.
Lucas, it has been a pleasure. Thank you for your truthful and thought-provoking reflections. You have been very clear on the fact that we should be thinkers and not just followers a little bit, if I can sum it up for Latin American countries. We are at our time, so unfortunately we are not going to be able to continue with questions, but on behalf of the organization team, I would like to sincerely thank each of our distinguished panelists. Your expertise, Lucas, has been enriched in understanding the challenges and opportunities in today's international tax landscape. So I want to extend our gratitude to the International Fiscal Association, the Chilean branch, and also to Universidad de Concepción for their generous support and collaboration in making this event possible. Thank you so much. And just so you know, for everyone watching, the link and the webinar is going to be posted on YouTube for anyone to follow on their own time. So thank you so much to everyone that joined us today, and thank you, Lucas.
Thank you.